attorney to let them know you will have court tomorrow. No one else will do that for you. If you wish to move forward without your attorney present, we can do that. If you do not have an attorney, I will ask you if you can afford to hire a lawyer. If so, we will make a note of that and move on. If not, and you qualify, I can provisionally appoint the Office of the Public Defender to represent you pending you filling out a formal application. You have a right to have your attorney present before and during any questioning. Third, if there are any challenges to probable cause, I will address those. Fourth, I will review your bonds and or release conditions with you to determine if any changes are necessary. Be aware, if this court places you on pretrial release today, regardless of whether it is straight pretrial release or a condition of your bond, the conditions announced in court today go into effect immediately, meaning even while you remain in custody. For example, if you are told to have no contact with a certain person and you call that person from the jail before you are released, you are in violation of pretrial release. Throughout the entire process, you have a constitutional right to remain silent. If you choose not to remain silent, anything you say can be used against you. Everything that is being said where I am located at the courthouse, as well as where you are located at the jail, is being recorded. There is an assistant state attorney present listening to everything that is being said, and also everything he's listening to what's being said and everything's being recorded. So do not say anything about the crime itself. Please keep these rights in mind as we go through the process. Please step forward as your name is called.
Atención, esta es su audiencia de primera comparecencia. La audiencia de primera comparecencia tiene solamente 4 propósitos. Primero, le informaré sobre el cargo o los cargos que han presentado en su contra. Segundo, le preguntaré si ya le está representando un abogado. Si ya usted ha contratado abogado y este se encuentra presente, entonces será el abogado quien hable en representación suya. Si su abogado no se encuentra presente, usted tendrá la opción de proceder con su audiencia de hoy o posponerla hasta mañana. Si usted decide posponerla, será su responsabilidad contactar a su abogado para hacerle saber que tendrá una audiencia. Nadie más hará esto por usted. Si usted desea proceder sin que su abogado esté presente, puede hacerlo. Si usted no tiene abogado, le preguntaré si puede pagar uno. Si usted puede, tomaremos nota de esto y procederemos. Si no puede y califica, el juez asignaría provisionalmente a la oficina del abogado de oficio para que le represente en espera de que usted llene una solicitud para estos servicios. Usted tiene derecho a que un abogado esté presente antes y durante cualquier interrogatorio. Tercero, si hay alguna objeción en cuanto a motivo fundado, estas se abordarán inmediatamente. Finalmente, voy a estar revisando sus finanzas y otras condiciones de liberación con usted para determinar si es necesaria cualquier modificación. Debe saber que, si el juez lo pone hoy bajo libertad condicional, independientemente de si es directamente o como condición de su fianza, las condiciones que se anuncien hoy en esta audiencia entrarán en efecto inmediatamente, aunque usted se encuentre aún encarcelado. Durante todo este proceso, usted tiene el derecho constitucional de permanecer en silencio. Si decide no permanecer en silencio, todo lo que diga podrá ser usado en su contra. Todo lo que se diga donde yo me encuentro, así como también donde usted se encuentra, está siendo grabado. Hay un abogado de la fiscalía presente escuchando todo lo que aquí se dice, así que no diga usted nada sobre el delito en sí. Por favor, tenga presente estos derechos durante el transcurso de este procedimiento. Favor, pasar al frente cuando se llame su nombre. Gracias. Thank you.
All right, we're going to start with the Spanish cases first. First up, we have Felipe Gregorio Flores. Sir, you've been charged with driving without a valid driver's license and driving under the influence.
Señor, Se le acusa de conducir sin una licencia válida para manejar y conducir en estado de ebriedad.
Because of your illegal status in the country, both of those charges have been upgraded by 1 degree.
Debido a su estatus ilegal en el país, ambos cargos han sido incrementados de un grado.
Do you want me to appoint an attorney, or are you going to hire an attorney that you choose?
¿Quiere usted que yo le asigne mediante el tribunal un abogado o contratará usted uno de su elección?
Me asigne uno.
For one to be assigned.
All right, sir, I'll go ahead and provisionally appoint the Public Defender's Office.
Bien, señor. Provisionalmente le asignaré la oficina de defensores públicos.
I have reviewed your affidavit from the sheriff back in my office during lunch.
Durante la hora de la comida revisé la declaración jurada del alguacil en mi oficina.
I do find probable cause for the 2 charges.
Existe motivo fundado por ambos cargos.
You set your bond on the DUI at $2,000.
Por el cargo de conducir en estado de ebriedad, la fianza se establece en $2,000.
Your bond on the no valid driver's license is $1,000.
Tu fianza por la licencia válida para manejar se establece en $1,000.
And because you have a hold for you from ICE, I will ask the clerks to prepare a detainer for my signature.
Ya que tiene una orden de detención en su contra de la Agencia de Inmigración ICE, le pediré a la Secretaría Judicial que prepare una orden de detención que yo firmaré.
Have a nice day, sir.
Que pase buen día, señor.
Next up is Elder Giovanni Hernandez Madrid. Good afternoon, sir. You're here because you have a warrant from Hillsborough County for failing to appear for court.
Buenas tardes, señor. Está aquí
Buenas
porque tiene una orden de detención del condado de Hillsborough por incomparecencia en el tribunal.
The charge over in Hillsborough is for domestic battery.
El cargo en el condado de Hillsborough es por agresión física intrafamiliar.
Because the charge is a Hillsborough County charge, I cannot appoint a Polk County public defender.
Ya que el cargo es del condado de Hillsborough, no lo puedo nombrar un defensor público del condado de Polk.
You can either hire a lawyer now or wait till you get back to Hillsborough to request the services of the public defender.
Usted puede o contratar un abogado privado ahora o esperar a que llegue al condado de Hillsborough para solicitar los servicios del defensor público de allá.
From the paperwork that I reviewed prior to court, I find probable cause to hold you.
De la documentación que revisé antes de esta sesión, encuentro que hay motivo fundado para detenerlo.
The judge in Hillsborough wants you held no bond.
El juez del condado de Hillsborough quiere que quede detenido sin fianza.
We'll notify Hillsborough that you're able to be picked up.
Le avisaremos a Hillsborough que lo pueden venir a buscar.
If you're still in our jail, a week from today, you'll be brought back to talk to a judge.
Si sigue en nuestras cárceles en una semana, volverá de nuevo a estar ante un juez.
Sir, you also have a hold from ICE.
Señor, usted también tiene orden de detención de la Agencia de Inmigración ICE.
We do detainers on these as well, correct?
Yeah.
So I'm going to ask the clerks to prepare a detainer for my signatures.
Así que le pediré a la Secretaría que preparen una orden de detención que yo firmaré.
Step to your left, sir.
Pase a su izquierda, por favor.
Next up is Juan Camacho Resendez. Sir, you are also charged with a warrant out of Hillsborough County for violating your probation.
Señor, usted también está acusado mediante una orden de arresto del condado de Hillsborough por incumplir la probatoria.
Just like the last gentleman, I cannot appoint a public defender in Polk for a Hillsborough case.
tal como pasó con el caballero antes de usted, no lo puedo nombrar un defensor público del condado de Polk, porque el caso es de Hillsborough.
You can hire an attorney now if you want to, or ask for the public defender once you get back to Tampa.
Usted puede contratar un abogado privado ahora si usted quiere, o solicitar un defensor público una vez que vuelva a Tampa.
The circuit judge over in Hillsborough signed this warrant that I'm looking at.
El juez de circuito del condado de Hillsborough firmó esta orden de arresto que estoy revisando.
I find probable cause and will hold you no bond.
Encuentro que hay motivo fundado y lo detendré sin fianza.
We'll tell Hillsborough that you're free to be picked up.
Le avisaremos a Hillsborough que está disponible para que lo vengan a buscar.
If you're still here next Friday, we'll bring you back to talk to a judge.
Si sigue aquí el viernes que viene, estará ante un juez nuevamente.
Have a nice day, sir.
Que pase buen día, señor.
We now have Jonathan Rodriguez Figueroa. Sir, you're charged with violating your misdemeanor probation on the charge of battery.
Señor, está acusado de incumplir su probatoria por delito menor debido a un cargo de agresión física.
Do you want me to appoint the public defender to represent you?
¿Quiere usted que le asigne los defensores públicos para que lo representen?
No, se supone que mi abogado esté presente.
No, my attorney is supposed to be present.
All right. Do we have any attorneys either in person or virtually for Mr. Rodriguez Figueroa?
¿Está presente algún abogado virtualmente o en la sala para el señor Figueroa?
No one has announced that they're here, sir. Do you want to postpone this until tomorrow morning?
Señor, nadie ha anunciado que está aquí. ¿Quiere usted aplazar o posponer esta audiencia hasta mañana en la mañana?
Sí,
Yes.
Didn't we postpone it yesterday?
Your Honor, I thought.
Yes.
yes.
Yes, sir. This is, it's already been 2 sessions. I'm a little concerned.
Who is this?
Ya han sido 2 aplazamientos, señor. Estoy un poco preocupado.
Sí, yo hablé con el abogado ayer y me dijo que iba a estar presente. No sé por qué no está presente.
I did speak to the lawyer yesterday and they told me that they would be present. I'm not sure why they're not here.
Your Honor, if I just may have asked if he could tell us who his private lawyer is, that I could let them know.
La señora de la Defensoría Pública está preguntando si nos puede decir quién es el nombre de su abogado privado para ella entonces avisarle.
Mark Henry,
Exactly.
Kendrick?
Mike Henry.
Yes.
McKendrick,
I'm
Richard
sorry.
McKendrick.
Henry.
Richard McKendrick. Richard McKendrick.
That's why I couldn't find it. I looked online for it.
Okay.
Richard McKendrick.
Yeah. So, sir, you want to try one more time? I'll bring you back tomorrow morning. The weekends, we do it in the morning.
¿Quiere intentar otra vez, señor, en la mañana? Los fines de semana se hacen en la mañana estas audiencias. Okay.
All right. If that's what you want to do, then, sir, we'll bring you back for one more shot to get your attorney here. Have a nice day. We'll see you tomorrow morning. Ms. Baglini, can you make an announcement? Those are the only 4 I was aware of.
Atención, si alguien más necesitará asistencia al español, por favor, levante su mano ahora. Hearing none, may be excused.
You bet. Have a great rest of your Friday.
You
Do we have any private attorneys here that want to have their cases called up first?
Yes, good afternoon, Your Honor. Attorney Alexandros Lemonides here on behalf of Efrain Pacheco Cardona.
1 second as I retrieve the paperwork.
Yes, Your Honor.
Your Honor, I believe this was called back again today because we were waiting for the lawyer to.
We have,
No, they were on the list yesterday. He came and now he's on the list for today.
That's correct, Your Honor. If you remember, my colleague, Mr. Nielsen, appeared, but Mr. Pacheco Cardona had not made the list. I guess he was booked a little late last yesterday morning.
Yeah, I do remember the young man was here at the beginning and we just didn't have him on yesterday's list. So I was pretty confident he would make it onto today's list.
Yes, Your Honor, and I appreciate the accommodation for a Teams appearance or a Zoom appearance, if you will.
Not a problem. No reason to make you burn up the gas and clog up the roads around Christmas to get here.
Yes, Your Honor.
All right, let's call up Mr. Pacheco Cardona.
Central.
He's been charged with DUI, driving under the influence, refusing to submit to a breath alcohol test, and lastly, exposure of sexual organs. Mr. Lemonitis, are you going to be representing him on these three charges?
Yes, Your Honor. He's already retained my office. I spoke with his wife yesterday. I do have probable cause challenges on 2 of the 3 charges, if Your Honor wants to hear those, and then I can give Your Honor mitigation or consideration for bond as well.
Sure. Now we're at the point of, we're up to step number 3 now. Told him what he's charged with. You've confirmed you're representing him. So now we're at the probable cause stage. So go right ahead with any probable cause challenges.
Yes, Your Honor. Regarding the exposure of sexual organs charge, it's my understanding from the probable cause affidavit that there was some public urination that occurred at the establishment that Mr. Pacheco Cardona was a patron of. We are challenging probable cause as to one of the elements of the charge, that somebody actually witnessed the exposure and that it was in an indecent, vulgar, or lascivious manner. Your Honor, I understand that this charge is normally a municipal or county ordinance in most counties. I understand that Polk County does not have that ordinance charge. I have seen it under other circumstances charged as a disorderly conduct. And what I believe the sheriff's office may have done is try to shock the conscience with a sexual exposure charge. I don't know that anybody actually witnessed the urination or Mr. Pacheco Cardona's sexual organs to be offended by that act.
All
So I
right.
am
What about
challenging.
Go right ahead. I'm sorry. I was going to say, what about the next one?
So as to the refusal, Your Honor, Mr. Pacheco Cardona was taken to the jail for booking after an investigation was performed regarding the DUI. He has informed me, and his wife has also confirmed, that he is an asthmatic and was unable to meet the breath volume required, but he was still charged with refusal under the new statutes that were put into place in October. I don't have medical documentation for this presently, but I can certainly provide it to the state. I'm asking the court to consider that he did attempt to provide a sample, but was unable to meet the volume. The CRA says something about him manipulating his breath, but I don't understand that to be the situation at all. So, Your Honor, I'm asking for statutory bonds regarding these 2 charges, or a denial of probable cause on those as well.
Mr. Matthews, what says the state?
Your Honor, 800.03 is a Florida state statute. It reads, in pertinent part, a person commits the unlawful exposure of sexual organs by A, exposing or exhibiting his or her sexual organs in a public place or on the private premises of another. Or, and then it goes on to say, or so near thereto as to be seen from a private premises in a vulgar or indecent manner. So with all due respect to defense counsel, there's not an element there that it be actually observed. That being said, by reading the probable cause affidavit, the witness, Mr. Chambers, saw the defendant throw 2 beer bottles away and urinate on the building. So the state position would be, for purposes of first appearance hearing, that the elements of the statute are stated and probable cause is present. With regard to refusal to submit, if the accused failed to provide an adequate sample, the state's position is that is a refusal. If there is some medical reason he was unable, that is a matter for evidence later down the line. But at first appearance hearing, the state's position is the allegations are sufficient to meet the statutory definition of the crime, and therefore the court should find probable cause. Thank you.
Any response, Mr. Lemonitis?
Briefly, Your Honor, if he is charged under Florida Statute 800.03, subsection 1, subsection A, The Florida Standard jury instructions as to element 5 are the exposure or exhibition caused offense to one or more persons viewing it, Your Honor. I don't see anything in the probable cause affidavit that says this person, Ms. Chambers, was offended by that. So I'll renew my objection to probable cause on that count, Your Honor. And regarding the refusal, I understand what the statute or what the state is saying. There are alternative means that Mr. Pacheco Cardona could have been tested, including a blood draw or a urine sample, and he would have willingly provided that.
All right, here's what I'm going to do. And I am aware of the case law that talks about urinating in public, that I'm paraphrasing, but basically when nature calls, you know, you can't be held responsible if you urinating in public. That's a paraphrase of what I think the gist of the case law is. Now, at the same time, that urinating in public is not all created equal. I suspect someone could urinate in public and put on a show or do something that offends other folks that are viewing it. With all that being said, I'm going to find no probable cause for the exposure of sexual organs because it's rooted in that he was urinating in public. And to the defense's point, it doesn't show anything in there that anyone was offended. I do find probable cause for the DUI and for the refusal to submit. I'm going to set his bond at 2,000, or you said you wanted to do mitigation. Go right ahead if you have some mitigation.
Oh, of course, Your Honor. Thank you. Just that Mr. Pacheco Cardona has been living in Polk County for several months after moving from Puerto Rico. His wife lives there with him. She did want to appear for this afternoon, Your Honor, but I advised her that I would take care of this now that we were retained. He does have 3 children. They're older, Your Honor. They're all over the age of 18, but he does, provide for them in some respect. He's had a new job recently with Fit Life, which he's had since September. And Your Honor, if Your Honor will grant a reduced bond, he has, of course, retained my office. We'll make sure that he makes all court appearances and abides by all conditions that the court might put in place.
I see that he has open cases already in CT 257514 and MM 257725. What are
Yes,
those
Your Honor.
charges?
7725 is resisting an officer without violence.
So, Your Honor, he's in front of Judge Flynn on those charges. One of those charges was a driving without a license. When Mr. Pacheco Cardona came to Florida from Puerto Rico, he had to obtain a driver's license. By the fact that he was driving in this particular matter, I'm assuming that he did obtain that driver's license. I believe he had an appointment 1 week prior to this, and he's received his license. I understand now, obviously, it will be suspended as a result of this, but I am working with the prosecutor to try and resolve that case.
Okay. Having found probable cause for 2 of the 3 charges, he'll be ROR'd on the exposure of sexual organs. He's going to be held with a $2,000 bond on the DUI and a $1,000 bond on the refusal to submit to a breath alcohol test. And I am going to revoke his bonds on 25 CT 7514 and 25 MM 7725. I'm going to hold him no bond pursuant to the authority of Parker versus State. Mr. Lemonitis, is he being represented? I think I heard you say he is being represented by you on those 2 charges?
Yes, he is, Your Honor. And would this be subject to any motion to reinstate bond that could be heard by Judge Flynn?
Yeah, sure. No, you absolutely. It looks like the court date that's presently set is January 15. Sure, if you can get in front of Judge Flynn with a motion, absolutely, you're able to do that. You know, he has every right to revisit what I did here today. But yeah, the person being out on bonds for 2 criminal offenses.
I totally understand, Your Honor. I totally understand.
And picking up, being arrested for 3, being probable cause for 2, I think that's appropriate. All right, sir, anything else?
No, Your Honor, thank you. And we will, if I need to, I will try to expedite resolutions with Mr. Molinax and get an earlier court date. I'll just need to speak with Mr. Pacheco Cardona about that. Absolutely. Nice to meet you. Have a great rest of your day. Yes, Your Honor. Thank you. All right. Any other private attorneys? All right. Let's get started. Folks, I'm going to
There's really four things, just like my little speech said. I tell you what you're charged with in case you don't already know. I make sure you know you have a right to a lawyer, and if you want one, I can appoint a public defender. Provisionally, that means you're going to have to go and fill out a more formal affidavit at some point just to prove that you qualify, because not everybody qualifies. Basically, people like Elon Musk or people that are well-to-do are not going to qualify, but a lot of people do, candidly. The third thing is I determine probable cause. Just so you guys know, I've already read everybody's affidavit back in my office. I've spent the last couple of hours doing that to be prepared for court. But the attorneys might have some challenges, just like that last case, and I'm going to listen and make a decision that I think is best. And lastly, I'm going to set bonds and put people on pretrial release on many cases, specifically ones involving domestic battery. A lot of people sometimes want to talk a lot. Just like this, I try to be a patient judge, but there's a time in life to talk and probably a time not to. Most people would tell you this is not a time to do much talking because everything's being recorded. And you guys, I know y'all want to tell me things like, hey, Judge, it didn't happen like you think it did. I didn't do this. I get it. I understand. I probably want to say the same thing if I was in your shoes, but know this. My job is not to tell you today whether I believe it happened or not. I wasn't there. I don't know. If I by chance was there watching what happened, I'd be a witness and I couldn't be the judge. So it doesn't work that way. My job is to review this document that the police used to arrest you and determine if there's probable cause. I use that word, accentuate that word so you guys know probable cause is a low hurdle. It's not a big hurdle compared to what's needed to win at trial. So if the state wanted to try to prove this at trial, it's a much, much higher hurdle, much higher burden. So today, I'm not determining that you did it. I'm determining whether or not the policeman alleged things in this document that overcome that small hurdle. So you telling me things like, hey, Judge, X, Y, and Z happened. I didn't do this. In the process of trying to help yourself, you might shoot yourself in the foot, say some things that are going to be recorded. Wouldn't it be ironic if you go to your trial where they try to prove it by this much? And the first piece of evidence is they play the hearing from today where you talk, even though I told you you shouldn't do it, okay? All right, with that being said, we're going to do the gentlemen at South County, the ladies at Central, and finish up with the men in the back. Let's call up Dylan Blakely. Mr. Blakely, you're charged with resisting without violence. Do you want me to appoint the public defender?
Yes, sir.
I'll appoint them to represent you, and all this is, anytime I appoint them, it'll be provisionally, but I'll appoint the public defender. I've looked over your affidavit from the sheriff. I find probable cause. Your bond is set at $1,000. Have a great day, sir. That brings us to David Brown.
Yes, sir. This way.
Mr. Brown, you're here for a total of 7 things. 3 counts of resisting an officer with violence, 2 counts of threats of death or serious bodily injury to a police officer or public official, 1 count of battery on a law enforcement officer, and lastly, you have what's holding you as you failed to appear for court on a trespass charge. Sir, do you want me to appoint the public defender on all 7 of these charges?
Yes, sir.
All right, I'll go ahead and provisionally appoint them on all 7. Let's start with the easy one. On the failing to appear for court, it's pretty clear to me that Judge Cole, who's out there in Haines City at that courthouse, must have known that you didn't get notice of your court date. And as a result of that, he did what we call an ROR capias. Capias is a fancy way of saying a bench warrant. And ROR is basically like he knew you didn't know about it. He had no other way to notify you because the addresses he had were no good. So he kind of like a fisherman. He ordered that you be caught and released. So the police were supposed to come into contact with you, arrest you, give you a new court date, get a good address from you, and release you. Well, so that's what I'm going to do. I'm finding probable cause, ROR you on the trespass. Now let's turn our attention to the 6 new charges filed by the Winter Haven Police Department. I reviewed the affidavit from that agency, finding probable cause for all 6 charges, taking note that you have 95 pages of criminal history. Woo, that's a lot.
96 now.
Well, your head might be headed in that direction, sir, when they add these to it. So with that being the case, I'm going to set your bonds on each of the 3 counts. I do find probable cause for all 6 of the new charges. On the 3 charges of resisting with violence, it'll be $5,000 per count. On the threats of death or serious bodily injury, 2 counts, I'll do 2,500 apiece. And the big one is the battery on the police officer. I'm going to set your bond at 10,000. I think you add all that up, that's $30,000. That'll be a condition. That'll be condition of your pretrial release. So if you're able to post bond, you have to immediately check in with pretrial release services. That's here at Bartow. Sign up with them and call them on Tuesdays and Thursdays. You have all the standard conditions that everybody on pretrial has, but you also have special conditions number 16 and 17 and 21. 16 says you can't have any weapons or firearms or ammunition in your possession. 17 says you can't have any intentional contact with the victims. Stay 500 feet away from them and their homes and their vehicles, place of employment. And lastly, condition 21 says you must stay 500 feet away from the location where this arrest took place. Have a great day, sir.
At my job site, I guess.
That brings us to Nathaniel Chapman Weaver. Sir, you're charged with possession of methamphetamine and possession of paraphernalia. Do you want the public defender?
Yes, sir.
All right, I'll appoint them to represent you. Sir, I've looked over the sheriff's affidavit, finding probable cause, recognizing that you're currently out on bond right now on a felony domestic battery by strangulation. I'm going to find probable cause for these 2 charges, enhancing your bond to $7,500 on the meth and $2,500 on the paraphernalia. I am going to take you into custody on 25 CF 6637. I'm going to hold you no bond pursuant to the authority of Parker versus State. And I will appoint the public defender on that case if you don't already have an attorney. Have a nice day, sir. That brings us to Brian Caro.
Yes, sir.
I hope I pronounced that right, sir. Sir, you are charged with violating your probation. What puts you on probation is reckless driving and driving while license suspended. Do you want me to appoint the public defender?
Yes, I was.
All right, if you want the public defender, I'll appoint them. So I'll do just that. I'm looking at Judge Kaler, Judge Stacy Kaler's warrant she signed. Looks like she did it just a few days ago on the 4th. Finding probable cause. She wants you held no bond, but we'll send you to see her for her violation day on January 12th. Have a great day, sir. Robert Doherty. Mr. Doherty, you're charged with possession of methamphetamine and possession of drug paraphernalia. Do you want me to appoint the public defender?
Yes, sir.
All right, I'll go ahead and appoint that office to represent you. Sir, I reviewed the sheriff's affidavit, finding probable cause for these 2 charges. I also see that we're already out on bond on possession of meth and possession of paraphernalia and tampering with evidence. So what I'm going to do is, having found probable cause, I'm going to enhance your bond on these 2, $7,500 for the meth, $2,500 for the paraphernalia, and I'm going to take you into custody on 25 CF 7680, holding you no bond pursuant to the authority of Parker versus State, and appointing the public defender to that case if you weren't already assigned an attorney. Have a great day, sir. Next up, we have Rodney Frazier.
David, ask to be heard on this one.
Mr. Frazier, waiving of the reading?
Yes, sir.
All right, Mr. Frazier, you are charged with a 2nd-degree felony. You want me to appoint the public defender?
No, sir. A private attorney.
Okay, are you wanting to go forward today, or are you wanting me to postpone this till tomorrow when you've had a chance to get that attorney here? So totally up to you.
No, you can go ahead.
All right, sir, we will put down that you hired your own attorney, and just note this, and for you and everybody else sitting behind you, if you guys, something falls through with your private attorney, just because you said no to the public defender today doesn't mean you can't ask for them at any time in the future while your case is pending. You have that right to ask a judge or even go to the public defender's office themselves to request that they be appointed. All right, sir, I'm looking at an arrest warrant that was already reviewed and approved by Judge Seitz yesterday. So another judge has already seen it and already found probable cause, and that's led to your arrest. So I find probable cause based upon this warrant. As far as bonds, Mr. Matthews, go right ahead.
Thank you, Your Honor. Court having found probable cause, the state files a motion for pretrial detention on the F2 count. I would respectfully inquire the defense attorney's name so that my office can make a good faith effort to provide a copy ahead of the hearing. The state will ask the court to review this motion for legal facial sufficiency, and if so found, hold the defendant no bond pending a hearing on this motion. I believe that hearing should be set on Thursday, December 18th at 1 p.m. on the A2 docket. If I may approach.
Sure. Mr. Frazier, if you know your attorney's name, if you want to share it with us, Mr. Matthews says he'll make sure he sends a copy of this to your attorney.
I believe my girlfriend retained what's his name?
If you don't know,
Gil
that's fine.
Gil
Cologne, Your Honor.
Gil Cologne.
Okay, all right.
Gil Cologne.
That's what he said, Gil
Very-
Cologne. Yeah, and so, yeah, and once Mr. Cologne, once he's been properly retained, he, by rule, the attorneys are going to send to the court a document that notice of appearance. So we'll find out eventually if that's true. But for purposes of today, Mr. Matthews just wanted to know so he can send Mr. Cologne a copy. All right, sir. I am looking at a document. Let me count the pages. 4-page document, motion for pretrial detention. That's based upon Florida Rule of Criminal Procedure 3.132 and Florida statutes, which is the Florida laws, chapter 907.041, subsection 5C. I'm looking over this document, having already reviewed the warrant and the affidavit that's attached. From my review of this document, I find that it is legally sufficient, sir. And what I'm going to do is, based upon this document, I'm going to hold you no bond. But
What?
I'm going to hold you no bond, but you get to go in front of a circuit judge earlier
What is
next
that?
week. Yeah, and so a circuit judge will preside over this case, and we're going to notify Mr. Cologne, and Mr. Matthews is going to go in front of the circuit judge and potentially present evidence asking that you be held no bond indefinitely.
Oh, hold on. The number one person in here in this case got a bond of $7,000, and I'm number 2, and you don't get me no?
Yeah, that's correct, sir. You're right. I don't know anything about the other person. I haven't seen the other person's case. I'm just telling you, you had no bond until first appearance. We're here at first appearance. I was prepared to give you a bond, but before I did that, the state filed their motion. The law that motion is rooted in that law and that procedure that says if I find it legally sufficient, you get passed over to one day next week on the 18th to see a circuit judge to have a hearing. So that's what we're going to do. Have a great day, sir.
I explained it to you in the room.
Man, this bullshit.
Yeah, might as well go. And just,
She got
it's no bond now. He's going to be on,
Come on, man. You get called bond.
he's going to be on pretrial release with the following conditions: 16, 17,
Come on.
no contact with his codependent. Okay,
How many days a week?
for this one, what, Wednesday, Friday? They're not? Yeah, let's do that. Again, this is all going to need to be addressed with the circuit judge as far as the pretrial release conditions.
I expect I will be the ASA handling that hearing, and I will try to remember to tell the judge that pretrial release conditions were imposed even though he was held no bond. Sometimes that comes up at the hearing.
Sure, and yeah, absolutely, based upon the warrant previously filled out by Judge Sides, there's no contact with the victim, no weapons or firearms, and no contact with the codependents.
Yes.
Okay. All right, moving right along. Donnie Grimes.
Yes, sir. How are you today?
I'm good, sir. Thank you for asking. Mr. Grimes, you're here for 2 charges, felony battery and domestic violence felony battery. Are you planning on hiring a lawyer that you pick, or do you want the public defender?
I'm gonna hire an attorney. Yes, sir.
All right, sir, you have that right. And if you change your mind, you can ask for the public defender later. Sir, I've looked over the sheriff's affidavit. I find probable cause for each of these charges. I'm going to set your bond at the standard bond, which is for a third-degree felony, and that's what each of these is a third-degree felony. It's $5,000 cash or surety times 2 plus pretrial release condition. So if you post those bonds, you must immediately check in with pretrial, sign up with them, calling them on Tuesdays and Thursdays, all the standard conditions plus the following special conditions. Can't possess weapons, firearms, or ammunition. You can't have any intentional contact with a listed victim. This means directly, indirectly, or through a third party. You must stay 500 feet away from them, their home, their vehicles, where they work, where they go to school. The one that might be a little problematic is I see that you lived in the same residence with one of the 2 alleged victims. So if that victim is still there, you're going to have to find somewhere else to go. So for that reason, I'm going to let you go back at least one time with the police within 48 hours of your release from custody, accompanied by the police to retrieve your essentials like medicine and clothing and work tools, things of that nature. Have a great day,
Okay.
sir.
May I please ask a question?
Sure, go right ahead.
Okay, that is my house. The young lady that is living there, she is out on a ankle monitor for riding by, shooting up people's houses and all that stuff. And she done been to her daddy's and got kicked out. She done been everywhere and got kicked out. So I thought I'd give her a chance. Now, the police officer that wrote my thing yesterday did say that he was going to write a letter in there letting you know that he thought that was a bunch of bogus with her. Now, the only thing that I would like to ask also is I understand that I got bond. The only thing that I would like to ask also is if I can get out of this butt naked cell to where I can use the telephone. And the reason why I'm in there is because I needed a roll of toilet paper from the officer. I didn't show out. I'm not suicidal. I'm 100% sane, just like everybody else is. I just needed to use the restroom, and they would not let me use no toilet tissue. So I found myself in a butt naked cell, and I need to get to the phone where I can call my bonds lady to where I can get up out of here. But if that means I don't got to go home, that's fine. I won't never go back there. I just need to get up out of here. I got a life. I don't deserve to be here.
All right, Mr. Grimes, you covered a couple of grounds, and just know this. The last one about the toilet paper and about the naked sale, I assume you're talking about, suicide or risk protection, that kind of stuff.
Yes,
I don't have
sir.
anything to do with that. I hope you appreciate that. I don't tell Sheriff Judd how to run his jail, and he don't tell me how to run my courtroom. We try to both stay in our lanes when at all possible, unless there's a legal reason for us to go out of our lanes. So that's between you and him. The first thing you said was about, Judge, that's my house. I get it. Trust me. I understand what you're saying to me. But just know this. If that's her legal residence, you're going to have to find
That's
somewhere else to go. Okay?
I
That- again, I know you.
I screwed up. I screwed up by letting her come there. Yes, I did. Now, is there
Okay.
any way that I can get permission to use a telephone? And I will be done. That's all I need. I need to use a phone.
Yes, sir. Again, that's between you. You have a right to use the phone, sure, but that's between you and the sheriff as to how that goes down. I don't get involved in that. Again, I don't tell him what room to let you use a phone and how much money to charge you. That's between you and the sheriff, okay? All
Thank
right,
you,
sir.
sir.
You bet. Have a good day. All right, moving right along. Gregory Herndon.
Yes, sir.
Mr. Herndon, you're charged with driving under the influence with a breath alcohol content of 0.15 or higher. Do you want the public defender?
Yes.
I'll appoint the public defender to represent you. Sir, I can see you have a prior DUI in Orange County. So what I'm going to do is, taking that into consideration, plus your breath alcohol reading, they allege is, whoo, my goodness, 272, 276. That one's way up there. So what I'm going to do is I'm going to set your bond at $4,000 cash or surety and make it a condition of pretrial release. So if you post that bond, you must immediately check in with pretrial release, sign up in person, calling them on Fridays. You have all the standard conditions, plus the following special conditions. You cannot drink alcohol, none. You can't possess alcohol, none. You can't go to any bars, nightclubs, or lounges, any place whose primary purpose is the sale of alcohol. You'll be subject to random urinalysis, not breath. Breath ain't as good as urine. That urine will be able to tell if you've been drinking for like 3 or 4 days later. So I want you to do the urine. So I really mean it when I say don't be drinking. So you'll be subject to random urinalysis. They're going to put you in color code. So that means is Sunday night through Thursday night, you're going to have to call that color line after 7 o'clock. And if your color is read out on that recorded message, you got to drop everything the next day and hustle on down to the 4th floor drug court lab and provide a urine sample. And if it tests positive for alcohol or something else it shouldn't, then you're going to violate your pretrial release. You're also going to have a curfew of 9 p.m. to 6 a.m. So you'll have to be in your approved residence between those hours. All right, sir. Have a great day.
What if I work?
What if you work? What do you mean?
Yes, past 9.
You can show proof to the pretrial release officers that you have a set schedule. Now, you can't do one of these, oh, I work late some nights I don't, Judge. So when you catch me coming home at 11, I work late that night. Doesn't work that way. You're going to have to show them a schedule, things like that. But if you are at the job, they'll let you stay working. I'm not trying to deprive you of making a living. But at the same time, they know you're going to have to prove to them where you work, and they'll figure out how long it takes you to drive home. And they're going to give you, if you get off at 10, they're going to give you that much time to get home. No lollygagging or swinging by the beverage castle on the way home. So,
Not sure about the driving home part.
yeah, not the driving, but getting home.
Show proof to pretrial release set schedule.
Yeah, so if you work, I'm not trying to make you lose your job. That's not my goal there. My goal is to keep you from running around at night, at the time when a lot of people do their drinking, okay? Want you in your approved residence unless you're at work. Have a great day, sir.
Is there any way to lower that bond, because I do have to take care of my son as well as work?
No, sir. I think that's appropriate for someone with a prior DUI who blew a 272 and a 276. Have a great day. Alan Huggins?
Huggins is in, no, he's in the hospital.
All right, let's bring Mr. Huggins back tomorrow. Mr. Huggins comes back tomorrow. That brings us to Brett Judah.
Yes, Your Honor.
Mr. Judah, you're here on a VOP for a petty theft. You want the public defender?
I've already been issued one by Judge Kaler. I had first appearance 3 days ago.
You might have come in, that's probably what happened. You came in on a warrantless, my guess is. And, yeah, she signed this warrant I'm looking at. It's her signature. She signed it yesterday, or actually today. The 11th, isn't it? Yeah.
Challenge on this, Your Honor. Are you ready?
Well, challenge as to the probable cause?
Yes, sir.
Okay. Well, have you seen Judge Kaler's warrant? Just making
No,
sure.
not yet. Not yet, Your Honor.
Okay, well, yeah, I was just telling Ms. Goins, to make sure you had a copy of it. She signed it today. And, all right, so Ms. Goins, go right ahead if you have a probable cause challenge to Judge Kaler's warrant.
Well, maybe I don't understand how these things are listed, because I was going to challenge it because I did not have an affidavit that contained any allegations regarding the petty theft charge.
The petty theft, she is a VOP, so he's already on probation for petty theft. And he says he came through first appearance, so my guess is he might have had a warrantless VOP. I would have to go back and look what caused him to come through. And usually what happens when a warrantless VOP, maybe a policeman got you past curfew, maybe you picked up a new crime or something like that. Well, it takes a couple of days for the paperwork to catch up to Judge Kaler and your probation officer to find out why you got arrested. Then they put an affidavit in front of her with a warrant. She signed it today. So that makes, logistically, that makes sense that it took a couple of days for her to find out why you came through first appearance 3 days ago to sign the warrant. Now that brings you back to me, because now there's a second basis for you being here. The warrantless was the first one. Now the warrant has caught up with it.
And there's also an affidavit and showcase that is during that time frame, Judge.
Sure.
And it lists a number of violations.
Yeah.
But it appears to me that there's some new charges on here, and that's why I'm trying to figure out. That's what he came through first appearance on previously, and he's only here on the VOP today.
Yeah,
She found it in Stanter
yeah.
for the probation when he came through first appearance on the new charges. And that paperwork has now caught up with the case.
Now, I use the example of a policeman having you, calls you to be arrested. Mr. Matthews informed me it was her. So a policeman arrested you for something else. Pretrial is feeding me all kind of information on the screen to my left, such as you're out on bond like those other fellows out of Parkard, or that you're on probation. So there might be some people behind you that are on probation right now that got arrested yesterday and they see me today. Well, guess what? There's a possibility that I can take them into custody like she did you 3 days ago on what we call an instanter. She took you into custody because she found probable cause that she committed a new crime while you're on probation. Well, again, it took a couple of days for the paperwork to make it to her with a true warrant. So that's what's happened.
All right, thank you.
All right, sir. So I'm holding you no bond because that's what her warrant says. And you'll go see her. Your timing's not bad. You have a BOP date with her on the 23rd. Have a great day, sir.
You too, Your Honor.
Thank you. Gabriel Ridding?
Writing, yes, sir.
I apologize, Riding. Mr. Riding, you're charged with, you have warrants out of Hillsborough County. Looks like you failed to appear for court over there on burglary, criminal mischief, $100,000 or more, and petty theft, $100 or less. I can't appoint a public defender on a Hillsborough County case. You can always hire a lawyer or wait and ask for the public defender when you get back there. I've looked at the paperwork from the local authorities plus the information provided through the two sheriff's offices. I find probable cause. The judge over there is the one that has set your bond, but the judge over there set your bond at no bond. So we'll hold you no bond on each three. And if there's nothing else holding you in the Polk County jail, Polk jail will notify them, hey, come get him, because Polk doesn't want to pay for you to be in their jail, taking up a bed space. They'd rather you be over in Hillsborough. So they're going to call them and say, come get him, he's yours. If for some reason you are still here a week from today, we'll bring you back so you and that judge, whoever's here that day, can talk to you about what happens next. Have a nice day, sir.
Thank you.
You bet. Moving right along, we have Raymond Thomas.
Yes, sir.
Mr. Thomas, Ms. Goings, Laban on this one?
Yes, sir.
Mr. Thomas,
Yes, sir.
misdemeanor of the first degree, okay? First degree misdemeanor. Do you want me to appoint the public defender?
I'd gladly appreciate it.
All right, I'll be happy to do that if that's what you want. I'll appoint the public defender. I've looked over the sheriff's affidavit here in front of me. From my review of this document, I find probable cause. I'm going to hold you, I'm going to find probable cause and set a bond of $1,000. Have a nice day, sir.
You do the same.
All right, I think it's sent for South County. Did I miss anybody? Or has anybody been moved from Central that I wasn't aware of? All right, let's do the ladies. Ashmil Baez is charged with 2 counts of petty theft. Do you want the public defender?
Noise,
You want an attorney, public defender?
not to hire one.
Yeah, if you can't afford to hire one, do you want a public defender?
Yes, sorry.
Okay. We'll appoint the public defender. I've looked over the Lake Wells Police Department affidavit, finding probable cause. Looks like you've only been in Florida a month. So you don't have any record right here, but you don't have a lot of ties to the community. So ma'am, I'm going to leave your bond where it's at. It's standard bond, $250 per count, so $500 total. Have a nice day. That brings us to Adriana Bowe. This Bowe is charged with violating her probation on a petty theft charge. This Bowe, do you want the public defender?
Yes, sir.
Appoint them to represent you. I'm looking at a warrant, reviewed it already by Judge, looks like McDaniel, maybe? Judge is MD, I believe that's Judge McDaniel. How old is this?
It might be Judge Harvey.
That's
Judge Harvey.
That's hard?
Yes.
How in the world is, I've seen his signature, that's.
However you want.
You say so. Finding probable cause, Judge Harb apparently wants you held no bond. He signed this warrant today, so it's hot off the presses. We'll hold you no bond. You'll go to see him on January 5. Have a nice day, ma'am. Next up, we have Hope Cogswell. Ms. Cogswell, you're here for violating your probation. What put you on probation was possession of meth and possession of paraphernalia. Do you want the public defender?
Yes.
All right, I'll appoint them to represent you. Ma'am, I'm looking at an affidavit from your probation officer. The allegation is you tested positive in the office for methamphetamine, finding
Yes.
probable cause, holding you no bond. You'll go see the circuit judge on January 5. Have a nice day. Michelle Del Rio. Ms. Del Rio, you're charged with possession of cocaine and possession of paraphernalia. Do you want the public defender?
Yes, sir.
All right, I'll appoint them to represent you. Having reviewed the Lakeland Police Department affidavit, finding probable cause, setting your bond at $5,000 on the cocaine, $1,000 on the paraphernalia. Have a nice day. Marangeli Diaz. Ms. Diaz, you're charged with resisting an officer without violence. Do you want the public defender?
Yes, sir.
I'll appoint them. Finding probable cause from the Lakeland PD affidavit, setting your bond at $1,000. Have a great day.
Thank you.
With that, I believe we're up to Kaylee Garner.
Stone Hospital.
Kaylee Garner was here yesterday, or supposed to be here yesterday. She's in the hospital. We'll bring her back tomorrow for a third trial. Unless, Ms. Goins, you have something different you want to do.
No, sir.
Yeah, we'll bring her back tomorrow to see if she's available. All right, let's call up Denise Hartley. How would I know this amended? Does it say amended somewhere? I didn't know it was the amended. I just read what was provided to me, so it could be the amended. I just don't know.
That has to be heard on this at the appropriate time.
Ms. Hartley, you're charged with unarmed burglary of an occupied structure, domestic violence battery, and interference with custody. Does this look like this is the individual?
Okay, this, that one is missing. This is the one that's.
Ma'am, do you want me to appoint the public defender to represent you on this?
Yes.
All right, I'll go ahead and provisionally appoint that office. I have looked over, I read your affidavit from Bartow PD back in my office, but I've just been told there's a small modification to it, some additional information. So just to make sure I'm doing my job the right way, let me go ahead and look at the amended one to see what new information they provided.
And I might be able to expedite. The additional information is the name and the date of birth of the child that's alleged in the narrative. I believe there are no other changes.
Okay. So just details related to the child.
Yes, sir, because of the third count.
Okay. Ma'am, I reviewed the affidavit and the old one and have the new one right here in front of me and see that it's substantially the same with minor modifications. I do find probable cause for the 3 charges. Mr. Matthews, go right ahead.
Judge, I wanted to note that the allegations as presented, it is before the court, not as a burglary of the battery. It was a burglary of a dwelling. Burglary of a dwelling is an enumerated dangerous offense. Because the case is not before the court as a burglary of the battery, and because of the circumstances alleged, at this time, the state is not filing or does not intend to file a motion for pretrial detention. That being said, the state will be requesting, I mean, this still looks like a serious offense, Judge, even if the battery was not an egregious battery in and of itself. The state's position is that the allegations are serious. State would be seeking, as part of pretrial release, that the accused be ordered to have no contact with the named victim, of course, and no contact with the named juvenile victim for count 3, at least until further judicial proceedings.
Ms. Hartley, just so you understand what he was saying, just to be fair, there's a crime. Burglary is going into a structure or a vehicle for purposes of committing a crime. Many times it's stealing. But if that structure is a home, well, now it's burglary of a dwelling. So it goes from a 3rd-degree felony punishable up to 5 years to, when it's a home, it goes up to 15 years. So it's 5, 5, and 5. Now, if you go inside a structure and you commit a battery inside, burglary of a structure with a battery inside, or even a car, believe it or not, if you were to go up to someone who's sitting in their car, that's a conveyance, and you punch them through the window, that's a burglary with a battery. Guess what a burglary of the battery is? Punishable up to life in prison. So it's life in prison for don't talk. This is me just letting you know, okay? Burglary with a battery is punishable up to life in prison. And if I wanted to charge you with that, if I wanted to hold you no bond, I could, using my discretion. The state was saying, Judge, in this particular case, the police didn't charge her with burglary as a battery, all as one crime. They charged her with burglary of a dwelling, count 1, battery, count 2, instead of putting them together. So the way it is in front of me, it's burglary of a dwelling, occupied structure, which is punishable up to 15 years, and battery, which is a misdemeanor. But he's saying, Judge, it's still serious. You know, if they had to put those two together, she could be facing life. And you don't have to let her out of jail. So I just wanted to explain, so we weren't talking around you. That's what he was saying to me, that it's serious, Judge. So that being said, ma'am, I wasn't ignoring you. Just don't talk about the case, okay? You really shouldn't say anything. It's not going to benefit you potentially. So I find probable cause. What I'm going to do is I'm going to set your bond on the F2, burglary of a structure with a burglary of an occupied structure at $10,000. I'm going to set your bond on the interference with custody at $5,000. I'm going to set your bond on the domestic battery at $2,000. So you add it all up, that's $17,000. I'm going to make those bonds conditions of pretrial release. So if you post bond, you must immediately check in with the Office of Pretrial Release. This young lady beside me, she works for that office. It's right over here by County Probation on Highway 17. You have to check in, sign up with them in person, calling them on Tuesdays and Thursdays while your case is pending. You have all the standard conditions that anybody else has, plus the following special conditions. You're not allowed to have in your possession any firearms, guns, weapons, ammunition, or knives. You're not allowed to have any intentional contact with the listed victim in this case. Just so we're all on the same page, his initials are BG. That means directly, indirectly, or through a third party. Stay 500 feet away from him, his home, his vehicles, where he works, or where he goes to school. You don't share the residence with him, so there's no reason to let you go back there. And the last one is he is requesting that for the time being, that you not have any contact with the listed juvenile that was present. Now, her juvenile's date of birth is?
It's on the
amended when she's pulling it up, yeah. There it is. So that date of birth, yeah, she's, well, so ma'am, here's the other thing. So I am going to order that for the time being, keep in mind, anything I do today can be reviewed by the judge that your case is assigned to. But while this is still early and things are getting sorted out, I'm going to order that you have no contact with the juvenile listed in the amended affidavit. And because this alleged crime took place in the presence of a minor, by law, I have no choice. I'm what they call a mandatory reporter, like a teacher and a policeman. I have no choice but to notify DCF of this allegation so they can do their own investigation. So that's what I'm going to do. Truth be told, they probably already know from the police, but I have to do it as well. All right, ma'am.
I have comments I want to make on this. The court didn't ask me if I
Ask
had
you about
ones.
Oh,
This thing about no contact,
okay.
this is sort of a conundrum for this young woman. Because there is a family law matter involved in this. They had a time sharing agreement. And the allegation is that not that he was the sole custodian of that child, but rather he was there on visitation. And it appears to me that under those circumstances, that this court shouldn't be able to supersede the time sharing agreement that is already in place by a circuit judge in family court. And that's what the court's doing.
Well, Mr. Matthews, good point. I mean, I did it in abundance of caution. You were asked for it.
I would respectfully disagree because when the family court made its ruling, this defendant was not charged with a second-degree felony. The allegations in this case, the defendant went to the victim's home when the defendant had told her not to, for the purpose of retrieving a child who was in that parent's custody pursuant to that circuit court's order, and then forced her way inside using force against the victim to take the child from that home during the time that the circuit told this defendant that child should be with the other parent. So under those circumstances, until further proceedings, and her using force and not following the instructions of the circuit court, as alleged in this affidavit, that until there's further order of the court, best thing to do is keep everybody separated. And I think that the criminal case, even as a misdemeanor, would take precedence until further proceedings.
Yeah, it's going, like I said, I have no desire. I know this young lady and they have a judge that's assigned that's well-informed and attorneys potentially on each side of it. And some judge somewhere has made a decision on the child custody. I totally get it. I don't have any desire to interfere with that. That's not my goal. Mr. Matthews makes a good point as far as, that judge didn't know about what went down here. And it's clear from the affidavit that at least allegedly it was the other party's custody, and something happened that seemed to throw the judge's ruling out like yesterday's newspaper. As far as what they're alleging that you did, you disregarded that judge's order and you just went over there and decided to take the child, even though it was the other side's custody. So I have no desire, and I'm not going to be your judge, but whatever I do today can certainly be revisited. At least for the short term, I think it's probably prudent to just say no contact. And again, with DCF involved, they're probably not going to want you to have contact until they sort it out. So there's a lot of sorting out that needs to go on. At this early stage, I think it's probably the right thing to do, with acknowledging that I'm not a family judge. So go right ahead.
And also, with regards to DCF, I understand this court is supposed to be a reporter, but there was no harm to the child. This was a violation of a time-sharing agreement. That's what this is. This is not an allegation of that anything negative happened to this child such that you'd report it to DCF and that they would become involved.
Sure, I do it all the time when there's a battery in the presence of a child. I see everything from a 2-year-old in mama's arms and dad punches her in the face to a child's playing on the floor and dad pushes mom or mom pushes dad. My role is to report it to DCF. It takes place. I didn't say the child was the victim. I said it took place in the presence of the child. And that's what I'm hanging my hat on. I don't think I have any, I'm kind of surprised you're arguing on that one. The first one, I get it. The second one, why in the world, I just don't see why you think that I should not, as a mandatory reporter, report to DCF that a 12-year-old was present when allegedly a second-degree felony that included a domestic battery took place in front of the child. I'm just kind of wasn't expecting that one, but there's my response. I think I have no choice. It's not
That's
like I
my
think.
argument.
All right.
Anyway. So.
Yeah, no, I'm just like I said, that one, it just seems to be so cut and dry to me. I never alleged, or I don't think the state's alleged that the child was the victim. That's why I made sure I didn't call her the victim, but instead was present, and that she's the juvenile that was present and was listed in the affidavit. But I incorrectly made an inference or made it sound like the child was the victim. That is not what I've said. I've said she was present while a crime took place. So, all right. Moving right along, Heather Isa. I apologize. Wish I was batting 1,000, but unfortunately, I
Nelson,
get it wrong sometimes. Ma'am, you're charged with possession of methamphetamine and possession of drug paraphernalia. Do you want the public defender?
Yes, please.
I'll appoint the public defender to represent you, looking over the affidavit from the sheriff, finding probable cause, setting your bond at $5,000 on the meth, $1,000 on the paraphernalia. Have a nice day.
Thank you.
Tricia Higgins, you're welcome.
Huggins.
I'm sorry, I should have done better on that one. It is Huggins, clearly. Ms. Huggins, you're charged with possession of cocaine, possession of drug paraphernalia. Do you want the public defender?
Reed.
Yes, please.
Him to represent you, looked over the Haines City PD affidavit, finding probable cause. Set your bond at 5,000 on the cocaine, 1,000 on the paraphernalia, 1,000 on the paraphernalia, 5,000 on the cocaine. Have a nice day, ma'am. Next up, we have Shannon Hunter. Ms. Hunter, you're charged with violating your probation on felony petty theft. Do you want me to appoint the public defender?
Yes, sir.
I'll appoint them to represent you. Looking over Judge Harb's. Again, you're right. There it is again, but his name underneath it now. Finding probable cause based upon Judge Harb's warrant. Judge Harb, once you held no bond, will hold you no bond and send you to see him on January 5. Have a great day. Giovannia Nelson?
Yes, sir.
Ms. Nelson, you're charged by a direct information with child abuse. Are you wanting me to appoint the public defender to represent you?
Yes, sir.
All right, I'll appoint the public defender's office to represent you. Ma'am, I've looked over your information as well as your affidavit and the capias that was generated by the clerks when your charge was filed by the state. I find probable cause, going to set your bond at $10,000 and make it a condition of pretrial release. If you're able to post that bond, you must immediately check it with pretrial release, sign up in person, calling them on Tuesdays and Thursdays, all the standard conditions plus the following special conditions. You're not allowed to have any intentional contact with the listed victim. This means directly, indirectly, or through a third party. Stay 500 feet away from the victim, their home, their vehicles, where they work, or where they go to school. Mr. Matthews, any other conditions you're requesting on this one?
Yeah, may I have just a moment to?
Sure.
What?
Great notes on this, but I just get no contact with the alleged victim. There is a witness as well, but just to know if you wanted any broader, no contacts.
No, sir, at this time, stay satisfied with that.
All right, so ma'am, no contact with the alleged victim, condition 17. Have a nice day. Annette Parental? I apologize. Ma'am, you're charged with possession of meth and possession of drug paraphernalia. You want the public defender appointed?
Yes, please, sir.
I'll appoint them to represent you. Ma'am, looked over your affidavit from Lakeland PD, finding probable cause. Also see that you have a notice to appear for a misdemeanor case, and you have some, you have an extensive history, they say. I'm going to set your bond on the meth at $7,500, your bond on the paraphernalia at $2,500. Have a nice day, ma'am.
Thank you.
You bet.
Scoot's back.
You guys doing good? All right. Latanya Reed Lewis, I apologize. Latanya Reed Lewis. Give me a good bond. Ma'am, you're charged with domestic violence battery. Are you planning on hiring a lawyer, or do you want the public defender?
Lawyer.
Are you going to hire a lawyer that you pick?
Yes, sir.
Fair enough. If you change your mind, you can always ask for the public defender later. Ma'am, I've looked over your affidavit from the sheriff and I find probable cause. You have been recommended for straight pretrial release. Any updated victim comment sheet? Yeah, I don't think I have that. Oh, this is the gentleman that might want to be. All right, we have some information that the alleged victim may want to be heard. Certainly, here's your opportunity. While you're thinking about that, I'm going to read this new updated victim comment sheet. Alleged victim does not object to you getting out of jail, wishes to have contact, not seeking a restraining order, indicates no prior contact, or no prior, violence. does not fear future violence. Indicates you reside together, wants you to come home. And you've been recommended for straight pretrial release. I'm going to go along with that. I think you're the first one today. What that means is you don't have to post any monetary bond. I'll be letting you out of jail today. But you're probably not going to make it to pretrial by the time they close at 4. So you're going to have to do that first thing the very next business day, which will be Monday. So you have to report back down to Bartow Monday to that office, sign up with them, calling them weekly on Fridays while your case is pending. You have all the standard conditions of pretrial release, plus the following special conditions. You're not allowed to use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You are prohibited from having any intentional, no, I take that back. 16 is no weapons or firearms, and I am going to allow you to have contact with the alleged victim, but we're going to put in condition 20, which says you are allowed to have contact with the victim, but this contact is prohibited from being physically or verbally threatening. You can't be violent or abusive in any manner whatsoever. Any questions?
No, sir.
Have a great day, ma'am.
Your Honor, did Ms. Reed decline the PD's office?
She did. She said she's going to hire a private attorney.
Thank you, sir.
When we get to the ladies, when y'all start repositioning the men, I'm going to take a couple minutes for a break. And so anybody in the courtroom can take a bathroom break at that time if you want. Zeta Rodriguez,
Zeta Rodriguez is still at the hospital.
she was a bring back from yesterday, so we'll set her up for tomorrow. Bring back Zeta Rodriguez tomorrow.
We sent Soto back because she was being disruptive. So we put her on.
Soto was sent back.
Yes, Your Honor.
All right, let's put Miss Soto on the docket for tomorrow morning. So she'll have a quick turnaround. Maybe she's in better spirits tomorrow morning. So Soto is a bring back for tomorrow. Kamani Spence.
Yes.
Ms. Spence, you're charged with Ms. Goins, you waiving the reading on this one?
Yes, sir.
Okay, ma'am, you're charged with a 3rd-degree felony. Are you planning on hiring a lawyer, or do you want the public defender?
Public defender.
I'll appoint them to represent you. Ma'am, I've reviewed your affidavit. From my review of this affidavit, I find probable cause. Going to set your bond at the standard bond for this offense, which is $5,000, and make it a condition of pretrial release. Conditions on this one. Matthews, what are you asking for?
Judge, because of I want to honor the request of the defense, because of the nature of the allegations. The state's position is it has for no contact with the named victim until further proceedings. I understand that the allegations are such that it can kind of go one way or the other, broadly speaking. But because it's a first appearance hearing, state's position is we're not comfortable assuming it'll go the better way. Certainly with more information, a court might make a different decision, but at this point, state's seeking no contact with the victim.
Ms. Goins, candidly, this one's a tricky one too, based upon her state of residence and her being in Polk County on a temporary basis.
I can't tell whether DCF became involved. I don't know if they became involved in this. It isn't clear from the affidavit.
I sure would think so, but based upon the police officers being the mandatory reporters as well.
Yes, so
Yeah, and again, I'm getting this so quick after the alleged events. Things haven't really settled yet. The dust hasn't settled. I just want to do what's right by everyone involved as far as protecting the people that need protecting. So I am going to make the condition of your pretrial release that you not have any intentional contact with the victim. This means directly, indirectly, or through a third party. Stay 500 feet away from the victim, their home, their vehicles, where they work and where they go to school. And of course, like I've told others, you have every right to revisit this with the judge that's assigned to you, who will have more time to, preside over a hearing where he or she can get information from all the relevant folks involved. Okay, so Have a nice day, ma'am.
Thank you.
All right, Lindsay, 20.
Yes.
Ms. 20, you're charged with a violation of probation on a misdemeanor charge. Do you want the public defender?
Yes.
I'll appoint them, finding probable cause based upon, I believe it's Judge Flynn's warrant here. And he wants you held no bond. You'll go see him on the 20th of January. Have a nice day. Melion Van Hoos,
Yes, Your Honor.
man, you're charged. It looks like Judge Barber filed an order directing the clerks to issue a capias on the charges of aggravated battery, criminal mischief, and resisting without violence. Ms. Goins, is this one?
Client.
Yeah, I was gonna say, is this in a VOP posture? By that, I mean, do you want me to
No, sir.
appoint,
No,
to just,
the situation here, this is an NGRI for many, many years.
okay,
And what happened is she was being held down in Manatee County on another charge that was also an older charge that was being resolved. And therefore, I asked the Judge Barber to issue some kind of an order to have her brought here once Manatee County was done. So that is the case. How soon will this be put on in front of Judge Barber?
the clerks have put it up for January 27. Oh, I was looking at your next court date. 5-day hearing is 12/16. Yeah, her next court date.
This coming week. Yes.
The review is I should have looked at that. Review is January 27. The 5-day is the 16th of this
Right,
month.
that's what I wanted. All right, thank you.
You bet. All right, ma'am. So, your fine probable cause holding you no bond, not going to appoint the public defender because of the nature of this hold, but we're going to send you to see Judge Barber on the 16th of December. Have a nice day.
Yes, Your Honor, you as well. Thank you.
You bet.
For clarification, she was just put on probation in Manatee County just within the last week.
Is that all for the ladies?
Yes, Your Honor.
Give me a couple of minutes. I'm the duty judge and I have a couple of things to review on my end. So we'll sit here, you and align these, get these guys moving up to the front. That would always be helpful.
Oh, yeah, I'm gonna work on it.
That would be on the website, right? Zoom it, but it's called the weekend. I hadn't dealt with that.
Weekend holiday first appearance
Okay.
link.
Yes, we can on the holiday.
All right, welcome back, everybody. I'm gonna call one out of order. Let's call up Andrew Hall. Are we still muted? Mr. Hall, good afternoon, sir. You're charged with domestic violence battery and resisting an officer without violence. Do you want me to appoint the public defender's office to represent you?
No, sir, I'll get a private attorney.
Fair enough. You heard me tell everybody already, but you're always welcome to, if you change your mind, you can ask for the public defender later.
Roger that. Thank you, sir.
No problem, sir. I've already looked over the Bartow Police Department affidavit back in my office. I find probable cause for the 2 charges. Take a look at your record here. Show some history, but not extensive history. All right, sir, what I'm going to do is I'm going to set your bond on the domestic battery at $2,500. And on the resisting, the standard bond is $1,000. I'm going to make those bonds conditions of pretrial release. So if you're able to post those bonds, you have to immediately check in with the Office of Pretrial Release, sign up in person, and call them on Fridays. You have all the standard conditions of pretrial plus the following special conditions. Just make sure pretrial, you guys were never able to get a hold of the victim. So I don't know what the victim, I read some things that she told the police in the affidavit, but I don't know if she's said anything specifically related to you getting out of jail or conditions of contact. So what I'm going to do is I'm going to order that while on pretrial, you not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You're not allowed to have any intentional contact with the listed victim. This means directly, indirectly, or you can't go through a third person. You can't tell her friend to tell her something that from you. You can't contact her through social media or the internet. You have to stay 500 feet away from her home, her vehicles, where she works and where she goes to school. Just comparing your address on the affidavit to hers, they're different. So there's really no reason to let you go back and get stuff from her place. All right, I think we've covered it all. Have a nice day, sir.
So I have one question.
Yes, sir.
Just one. As far as our child that we have together, is that just a whole nother ordeal then? So
Yeah.
I can't.
I'm sorry, I didn't mean to cut you off. Yeah, I didn't, I knew where you were going.
Yes, sir.
What I did was I said, you can't have any contact with her.
Okay. Yes,
I didn't mention anything about the child because I'm not trying to be a divorce judge or a family law judge. And so you still have all the same rights with the child that a judge or your custody agreement dictates. Now, I acknowledge that it's kind of tricky, Mr. Matthews, as far as a child and not dictating that how about third-party contact for this limited purpose of child exchange and custody? There's got to be some way that he can.
I don't have any objection.
Yeah, so we'll make a modification. I don't want you to ever be in her presence while this
Yes,
case
sir.
is pending unless some judge changes it. But understanding you got a child and you guys got to make arrangements, I'll do this. You can go through a third person, your family member, her family member, someone that's willing to be a go-between, and you communicate with them, and then she'll communicate between the go-between, and then y'all can arrange, the child. I don't know how old the child is, but they can get very creative as far as how y'all can accomplish this. You can have the child transported by the family member, or depending on the age, y'all can meet at the police station, things like that with the go-between. Okay, so the bottom line is don't contact her while the case is pending until it's been changed. But I understand you still have a right to see your child, so you can go through a third party to accomplish that.
Roger that. Thank you, sir.
Yeah, have a nice day.
Yes, sir.
Thank you so much. All right, how about Joshua Aguiar? Mr. Aguiar, you're charged with possession of cannabis and possession of drug paraphernalia. You also have 3 warrants. 3 warrants out of Pasco County. Warrants are for felony possession of weapon or ammunition by a delinquent adult, possession of a controlled substance, and driving while license suspended. Sir, do you want me to appoint the public defender on the two new local charges?
Yes, Your Honor.
I'll appoint the public defender on the cannabis and paraphernalia. I cannot appoint the public defender on the Pasco. You'll have to wait till you get back there and ask for the public defender, or you can always hire an attorney now if you choose. Sir, yep.
I'm sorry, sir. There's also a holdup from Hillsborough.
Yeah, I don't even have that. That's appeared in front of me today. Do y'all have that? I will acknowledge that the first appearance list I'm working off of shows there's 6 cases, but the number 1 is not even present. So it starts with 2, 3, 4, 5, and then 6. So I don't know anything about a Hillsborough case. Huh? Yeah. So I guess if he's not in custody on that, I shouldn't be doing a first appearance on that. I suspect they'll bring him back tomorrow for some holdup on why he wasn't here today on that.
Sir, with doing something with it, if it's not on the docket, is those 2 things will miss. And one party has showed that first grade is already been held, so nobody's in front of the court, but nothing happens because the people who do something with the court order don't know the first appearance.
I agree. There's a temptation to do something, but it's probably best not to. Go ahead, Ms. Dawes.
He wasn't booked in on it. It just says hold on the booking sheet. It just says hold for Hillsborough. It doesn't say that he has a WAOJ out of Hillsborough on the booking sheet. He probably needs to be booked. Scroll up.
Yeah, so until there, yeah, I don't want to do a first appearance. It's putting the cart before the horse. All right, sir, having found probable cause, I'm going to set your bond on the 2 local misdemeanors at $2,000 each. And then I'm going to set the judges from Pasco has already set your bond at $10,000 on the possession of a weapon or ammunition by a delinquent adult at $10,000. He set it at $5,000 on the controlled substance and $1,013 on the misdemeanor driving while license suspended. All right, sir. So as long as you have these local charges, they're not even going to tell Pasco to come get you. But as soon as you either resolve the local charges or bond out on the local charges, they'll notify Pasco and bring you back to first appearance. So we can talk about giving you that 7 days until we bring you back.
Yeah, I hate to tell you.
That's all right.
He was booked in on the FTA for no ballot out of Hillsborough. I just missed it. It was the first thing on here. Looks like it says dispo release on own recognizance, but I don't know if that's this.
I think it was I think ROR like we do. So you're right. He was a catch and release. So they
Do
didn't.
you want us to add it on to the orders?
No, I don't think you need to, do you? Because he's already been released on it.
Oh.
Yeah, just like the Hillsborough judge had him arrested and given a Newport aid or got it after and released him. So he really no reason to.
Thank you.
That's probably, I did see that when I read the teletype.
Okay, thank you.
Yeah. All right, sir. Have a great day.
Wait, I do have one question. Am I able to ask him my question? Or? Okay, so I'm not from Polk County. Every phone call I'm trying to make is restricted. I have like phone calls I'm trying to make to get the bond money, but none of my calls is going through. So is there anything I can do about that, or how do I go about that? Do I just call a bondsman instead of like my family?
Yeah, you would have to call, you're gonna have to figure that one out yourself. Candidly, I just don't get involved with those kind of things. How the sheriff, like I said, I stay in my lane, okay? So you just have to talk it over with the sheriff or go through the bondsman, or you have a public defender now on the new charges. All right. Have a great day, sir.
Yeah.
All right, let's call up Sammy Betcho.
How you on
Good afternoon, sir. You're charged with driving while license suspended as a local charge. Then you have 4 things holding you here out of Pinellas County. Each of these 4 things from Pinellas, you failed to appear for court. They were for DUI, possession of paraphernalia, possession of prescription drug without a prescription, and then another charge of possession of prescription drug without a prescription. On the local charge, do you want the public defender?
Yeah, I didn't know that I had
Yeah,
court.
I'll appoint the public defender on the local charge, and again, you can hire one for the Pinellas matters or wait and ask for a public defender when you get back to Clearwater. Finding probable cause, setting your bond at $2,000 on the local, driving while license suspended. The judge over in Pinellas wants you held no bond on those 4. Have a great day, sir.
Sir, Honor, Your Honor, there's no way I could bond out for that and go there myself to the county because I didn't know.
No, sir. That's not my decision. That's the judge over there. The judge over there is the one that says no bond. I don't have a lot of discretion to change it. So that's between you
talk to
and,
him?
no, sir, I don't do that. You have an attorney though, and you can, like I said, they're not going to transport. You can bond out on the local charge and then they'll transport you over there. But no, sir, I really can't modify anything from Pinellas County. That judge over there is the one that said it at that.
When do you think they're gonna transfer me there?
I don't know, sir. You asked me about, what was your question again?
Like, how long will it take to transfer there? I left my family, so they pulled me out of my truck yesterday. I was on a vacation.
Yes, sir. I don't have my crystal ball with me. I misplaced it, so I don't know how to answer that question as far as how long. I mean, I'm being flippant, but my point is, I don't know. I have no idea. You have a local charge, and
Okay, so if I bond out on that, would they let me out?
if you bond out on that, then like these other folks I saw today that are here, and I say, all right, you got a hold from another county, we're gonna notify them to come get you. So I would like to think that they'll come pretty quick, but you've seen it already. Sometimes they don't. It takes a week or more. Well, in a week, if you're still here, I'll bring you back so we can talk about it. And we'll try to figure out where we go from there. I know that doesn't comfort you, but I just don't know what else to tell you. I don't have that ability to answer for them, okay?
You have to resolve the local charge before they'll be notified. You'll come back to first parents and that's when the week starts.
Now, it says no bond. Yeah, he's got no bond. Oh, yeah.
Unfortunately, Judge, this isn't, you're not putting this on for another review on 12/19 because he has a court case.
No, I told him, I said,
Make sure that was clear.
sir, yeah, they're not going to call Pinellas to say, hey, come get him. They're not going to. As long as you're being held in our jail, they're not going to do that. But you can bond out 10 minutes after you talk to me, and then guess what? As soon as you bond out here, they're not going to let you out. They're going to call Pinellas and say, all right, he's ready, come get him. But I can't tell you how long they take. But what will happen is once the local charges are done, the standard procedure is you get brought back to see me. Not even quite sure why that is, but that's what we do. And then that judge says, all right, well, we called them. Now they got 7 days and we'll put you on the docket for next week in 7 days. So yeah, you got those local charges until you do something with them or bond out. Nothing's going to happen on the Pinellas cases. Have a great day, sir. All right, on to Peter Beckton.
Yes, sir.
Beckton, you're charged with possession of methamphetamine. Looks like you failed to appear for your trial, your jury selection. Sir,
Yes, sir.
You already have a private attorney, Mr. Collier. I'm finding probable cause based upon your habeas, and going to hold you no bond, and you get a 5-day hearing with the judge you're in front of on the 17th. On the 17th, you'll go see your judge. Have a great day, sir.
Yes, sir.
Bill.
17.
Jerome Bell? Jerome Bell is charged with domestic violence battery. Sir, are you planning on hiring a lawyer, or do you want the public defender?
I'm a defender.
I'll appoint them. Sir, I've looked over the Winter Haven PD affidavit. I find probable cause. Setting your bond at $5,000 and making a condition of pretrial release. If you post those bonds, you must immediately check in with the Office of Pretrial Release, sign up in person, and call them on Fridays. All the standard conditions, plus special condition 16, which says no firearms or weapons can be in your possession. Condition 17 says you can't have any intentional contact with a listed victim, directly, indirectly, or through a third party. You have to stay 500 feet away from her home, her vehicles, where she works, or where she goes to school. Have a nice day, sir. Mr. Bodford, you're a bringback from yesterday. We talked to you yesterday about 2 charges that I did not find probable cause for. They were possession of meth and possession of drug paraphernalia. Specifically, even though, Mr. Matthews, I know you weren't here, but Ms. Goins argued that there is no testing that took place. She acknowledges that there's an excerpt from the third paragraph saying, he stated he doesn't know why it tested positive, but that's really not an affirmation that it was a positive test. So I thought it prudent to find no probable cause and set it over for today. Do you have any additional probable cause?
I spoke with the ASA who covered first appearance yesterday. The ASA informed me he reached out to the case filing agent. To his knowledge and mine, we received no additional information.
Okay. Bonifer, just like I told you yesterday, come back and they don't have any additional information, I was going to find no probable cause and release you on your own recognizance on these two. A recognizance is a bond. You're basically promising me that you'll come to court and you're supposed to. And that's important because I didn't dismiss these charges. I don't have a legal basis to. What I've done is let you out of jail. The state gets the final say in whether or not they want to file charges or not, because they're the one that has to prove it. So my point is just because I'm letting you out of jail doesn't mean these charges have gone away. Okay, does that make sense?
Yes, sir.
They still can charge them. They still can maybe change their mind and not charge them. We'll see. Time will tell. Okay. So you'll be ROR'd on these two, and your court date is going to be January 13. That's your court date, sir. Have a great day.
Still has a $250 bond on the driving under suspension.
Sure.
Okay, so that he could bond now.
Yeah, I think he wasn't brought back for that since we already handled that one yesterday. But yeah, he does have that.
That's all that's left now.
Sure, that's all that's left.
Thank you.
You bet. We are up to Enrique Carbajal. Mr. Carbajal, you're charged with possession of cannabis.
Alcohol bond.
Carbajal bond, I apologize. Did not know that. Terrence Carter. All right, sorry, Mr. Carter, got you bouncing around. Mr. Carter. Mr. Carter, you're here on 1, 2, 3, 4, 5 violations of your community control. Illegal possession of Brazolam, possession of oxycodone, possession of MDMA, 2 counts, and felon or delinquent in possession of a gun or concealed weapon. If you want the public defender,
Correct.
I will appoint them, finding probable cause, holding you no bond. Step to your left. Brings us to Michael Cheffin.
Yes, sir.
Mr. Cheffin, sir, you were charged with possession of cannabis, not more than 20 grams, resisting without violence, and possession of drug paraphernalia. Do you want the public defender?
Yes, sir.
Appoint them to represent you. Sir, I've looked over the sheriff's affidavit, finding probable cause for these charges. Setting your bond at 1,000 on the cannabis, 1,000 on the resisting, and 1,000 on the paraphernalia. Have a nice day. Rodney Cristofaro, you're charged with resisting without violence. Do you want the public defender?
Yes, sir.
Mr. Cristofaro, I'm going to appoint the public defender to represent you. I've looked over your affidavit from the sheriff, finding probable cause for this charge, setting your bond at $1,000. Have a nice day.
You too.
Thank you.
Bell?
That brings us to Anthony Dubell, who's charged with burglary of an unoccupied dwelling and criminal mischief, $1,000 damage or greater. Or do you want the public defender appointed to represent you?
I'll take a private.
Well, you're gonna have to hire a private if you want a private.
Right.
There's a bunch of them out there. So if you want time to try to hire one, sure, you can certainly do that.
Sir, can I ask a question?
Yeah.
I don't know anything about this. I don't know why I'm being charged with something I didn't. I don't know what's going on here.
Okay, sir. Well, like I said, being charged with, you're being charged with those two crimes. Another judge has already reviewed this and has already signed a warrant. And that was Judge Ojeda. He did it right around Thanksgiving. He signed it. I have reviewed it back in my office. Just jog my memory. Like I said, I reviewed it, but yes, sir. The allegation is you and your girlfriend broke into a dead man's home over on Lake Parker. Said the
No.
fella had passed away. No, you don't, I mean, just telling you, you don't have to comment on anything. I'm just telling you. Allegation was the fella passed away and his family lives out of town, but they own the property and the house was locked up and you busted in a window and you and your girlfriend burglarized it. That's the
No.
allegations. So, sir,
I
you don't
know-
have to agree
I
with
know
them. I'm
who
just
did
telling
that.
you.
I know who did it, but it wasn't me. Where I was. I got proof of where I was when all that happened.
Back to my question, do you want the public defender appointed to represent you?
Private, but
Yes, sir. So you, if you, just change your mind and want the public defender, you can ask for one later. I've looked over Judge Ojeda's warrant, finding probable cause, setting your bond at 15,000 on the burglary of a dwelling, 5,000 on the criminal mischief, making it a condition of pretrial release. If you post those bonds, you must check in with pretrial, sign up in person, calling them on Tuesdays and Thursdays, all the standard conditions, plus special conditions 16 and 17, and also no contact with the co-defendant, which is 23. All right, sir. Have a great day. Toby Foster.
Yes, sir.
Mr. Foster, your charge was one new crime, and then there's a warrantless VOP for 4 crimes. The new charge is that you're driving a motor vehicle with no insurance. Then the VOPs are for burglary, petty theft, cocaine possession, paraphernalia possession. You want the public defender on all 5 of these charges?
Yes, sir.
I'll appoint the public defender to represent you. Mr. Foster, I've reviewed the paperwork from the sheriff. Finding probable cause, setting your bond at $1,000 on the not having insurance on the vehicle you were driving. And because of that, I'll find probable cause for the VOPs for the other 4. You'll be held no bond on those. You'll go see the felony judge for the VOP on 12/17. You won't go see the county judge for the insurance case until January 2. But you can bond out on that one if you decide to resolve the VOPs when you go see that judge on the 17th. Have a great day, sir.
Thank you.
David Garay.
Yes, sir.
Mr. Garay, charged with felony petty theft. Says you have at least 2 priors. Are you planning on hiring a lawyer or do you want the public defender?
I need a public defender, sir.
All right, I'll appoint that office to represent you. Sir, I've looked over the Lakeland Police Department affidavit. The allegation involves some incident at the Target on Hardin Boulevard there in Lakeland. I find there's probable cause for this charge. And based upon your 49 pages of criminal history, I'm going to set your bond at $10,000. Make it a condition of pretrial release. So if you post that bond, you must immediately check in with pretrial, sign up in person, calling them on Tuesdays and Thursdays, all the standard conditions plus special conditions 17 and 21. Says you can't have any contact with any target. Stay 500 feet away from their property line. Have a great day, sir.
When's my court date?
Your next court date is January 13. But again, you are bondable. You have a $10,000 bond. Have a nice day. That brings us to Harold Hendershot.
Yes, sir.
Mr. Hendershot, you're here on a writ of bodily attachment. That's like a child support matter out of Marion County. That's up there in Ocala area.
Yes, sir.
I can't appoint a public defender, but you can always hire a lawyer if you want. You do, I find probable cause to hold you based upon the paperwork that's been provided to me. The judge up in Marion did set you a purge. The purge for you to get out is $1,707. But if you don't purge out in that amount, we'll notify Marion County to come get you. They probably don't come up down here as often as maybe Hillsborough or Osceola, who are right next to us. They probably come pretty regularly. But if for some reason you're still in our jail next Friday on the 19th, we'll bring you back. It's the 19th, right? Yeah, the 12th. Next Friday, we'll bring you back to talk about it with the judge then, okay?
Yes, sir.
Nice day, sir.
You too.
John Hendricks?
Yes, sir.
Mr. Hendricks, you're charged with domestic violence battery. The allegation is you have a prior battery, so that makes it a felony. Do you want the public defender?
No, sir. I'm gonna hire a private attorney.
Fair enough. You heard me say it. If you change your mind, you can always ask for a public defender later. Mr. Hendricks, I've looked over in my office your affidavit from the sheriff. I find probable cause for this charge. And what I'm going to do is you've got 47 pages. Pretrial characterizes it as an extensive history. So I'm going to set your bond at $7,500, make it a condition of pretrial release. And that means these conditions start right now, so you can't reach out to the victim. But if you're able to post bond, you must immediately check in with the Office of Pretrial Release, sign up in person, calling them on Tuesdays and Thursdays, all the standard conditions plus special condition 16, which says you can't possess weapons or firearms or ammunition. You're not allowed to have any intentional contact with the listed victim. This means directly, indirectly, or through a third party. Taking a look at your address, it does appear to be the same as the alleged victim. So I'll do condition 18, which says, since you lived there before you got arrested, you get to go home one time and get your stuff within 48 hours of getting out of jail, but you have to go with the police. And I said Tuesday and Thursday, I'm changing that to daily. So it's a daily call-in. And the reason I want to do a daily call-in is I'm going to order, there were some allegations of death threats. So based upon that, I'm going to order that you be held in the Polk County Jail until you've been equipped with a GPS monitor. So I want to, when I tell you not to have contact, I really mean it. And the best way I can ensure that you don't, without us finding out, is to put you on a GPS monitor. I'm not making you do house arrest, just I want to know where you go. Specifically, make sure you don't go within 500 feet of her. Okay? Have a nice day, sir.
So I'll still have the bond is 7,500?
Yeah, 7,500, then you gotta wait to get a GPS monitor and then you're on pretrial release. So yes, sir. Have a
Yes,
great
sir.
day.
Thank you.
You bet. Lloyd Henson?
You're in the other cell.
Mr. Hinton, you're charged with possession of cocaine, possession of drug paraphernalia, and driving while license suspended. You want me to appoint the public defender to represent you?
Yes, sir.
All right, or I'm gonna appoint that office to represent you. I've looked over the affidavit from Lakeland PD. I find probable cause. Set your bond at 1,000 on the paraphernalia, 5,000 on the cocaine, 250 on the driving license suspended. Have a great day, sir. That brings us to Rodney Jackson. Mr. Jackson, you're charged with violating your probation. What put you on probation was petty theft and possession of anti-shoplifting counterfeit device. You don't see that very often, but that's what you're charged with. Sir, do you want me to appoint the public defender?
Yes, sir.
I'll appoint him to represent you. I've looked over Judge Harb. He's been the judge that's had the most of these today. His warrant for violation of probation, finding probable cause. He wants you held no bond. We'll hold you no bond, and we'll send you to see him on January 5. Have a great day. Cody Phillips Jordan. Sir, you're charged with petty theft, but the allegation is you had your face covered, which enhances it to a first-degree misdemeanor. Do you want me to appoint the public defender to represent you?
Yes, sir.
I'll appoint that office to represent you. When I said it, I apologize. The allegation is the theft was greater than 100, which makes it a first-degree misdemeanor. The fact that you had a face covering bumps it up to a felony. So it is a third degree felony. I stand corrected. I'll appoint the public defender. I'm looking over the sheriff's affidavit, having found probable cause, setting your bond at $5,000. Have a nice day.
Yes.
Yeah. That brings us to Earl Lacy. Mr. Lacy, sir, you're charged with possession of cocaine, possession of paraphernalia, and resisting an officer without violence. Do you want the public defender?
Yes.
I'll appoint them to represent you. Mr. Lacy, I looked over the Lakeland Police Department affidavit. I find probable cause. You got 90 pages. Whew, that wasn't the most today, but it's pretty close. Criminal history. I'm going to set your bonds at $5,000 on the cocaine, $1,000 on the paraphernalia, and $1,000 on the resisting. Have a great day, sir.
Yes, sir.
Jeremy John Ledford. Ms. Wayne, are you waiving the reading on that one?
Yes, sir, I am.
All right. Mr. Ledford, you're charged with a third degree felony. Do you want the public defender?
Yes.
Appoint them to represent you. Sir, I've looked over a warrant that was already approved by Judge Spoto yesterday. I find probable cause, setting your bond at $5,000. Have a great day, sir.
Yes, sir.
Daniel Mercer.
I'm out of here.
Mr. Mercer, you're charged with violating your probation on a domestic battery charge. You want me to appoint the public defender?
Yes, sir.
I'll appoint that office to represent you. I'm looking over a warrant. This one, well, you have it. That's the affidavit, and then you have page 2 of the warrant. I clearly see the no bond, but there it is. Yeah. Madam Clerk beat you to it. Yes, see, she has an affidavit, and then she had the page 2, but she didn't have page 1, which you have. Sir, I'm looking at Judge Harb's warrant that he signed about a week ago. Finding probable cause, he wants you held no bond, will hold you no bond and send you to see him. We tell you that's on January 5. Have a great day, sir.
Thank you.
I believe we're up to Raymall Pearson. Mr. Pearson, you're charged with possession of methamphetamine, possession of MDMA known as ecstasy, possession of a controlled substance without a prescription, possession of cannabis, and possession of paraphernalia. Do you want the public defender?
Yes, sir.
I'll appoint them to represent you. Sir, I've looked over the sheriff's affidavit, finding probable cause for all these charges. So we're going to set your bond at $5,000 on the meth, $5,000 on the MDMA, $5,000 on the controlled substance, $1,000 on the cannabis, and $1,000 on the paraphernalia. Added up, I think it's $17,000. Have a great day, sir.
Thank you.
Yeah. Derrickson Perez Irizarry.
Yes.
Sir, you're charged with possession of methamphetamine and possession of drug paraphernalia. Do you want the public defender?
Yes.
With them. Found probable cause after I reviewed your sheriff's affidavit, setting your bond at $5,000 on the meth and $1,000 on the paraphernalia.
You said
Have a
you
great
did,
day.
sir? No, you said you did find probable cause?
Yes.
Yes.
On what, how, so?
After I read it and I determined there was probable cause. Have a great day.
But it, man, you obviously didn't read it.
James C. Redding?
Yes, sir.
Mr. Redding, you're charged with resisting without violence, possession of cannabis greater than 20 grams, making it a felony. Do you want the public defender?
Yes, sir.
That office to represent you. Sir, you have an open case in 25 CF 9810, so I'm going to factor that into your bonds. You also have 47 pages of history. So after reviewing Haines City PD's affidavit. I find probable cause setting your bond on the cannabis at 7,500. It'll be 2,500 on the resisting without. And I am going to take you into custody on 25 CF 9810, holding you no bond pursuant to the authority of Parker versus State, and appointing the public defender on that case if you don't already have an attorney. Have a great day, sir.
All right.
Mr. Redding?
That was Mr. Redding.
Yes, thank you.
Mr. Samiro, have a seat. I'm going to pass you for a moment. Blaine Stackhouse? Mr. Stackhouse? Do we? We didn't already do Mr. Stackhouse, did we? I didn't think we did. I must have just marked the him on accident. Mr. Stackhouse, you're charged with domestic violence battery. Planning on hiring a lawyer, or do you want the public defender?
Public defender.
All right. Mr. Stackhouse, I'll appoint that office. I've looked over the sheriff's affidavit back in my office, finding probable cause. I'm going to set your bond at $5,000. That's the standard bond for a domestic battery. Going to make it a condition of pretrial release. So if you're able to post that bond, you must immediately sign up with pretrial release, sign up in person, calling them on Fridays. You have all the standard conditions plus special conditions 16 and 17. I'm taking a look at your address and comparing it to the alleged victim. It does appear to be different, so no reason to do 18. 16 says you can't possess or carry firearms, weapons, or ammunition. 17 says you're not allowed to have any intentional contact with the victim. This means directly, indirectly, through a third party. Stay 500 feet away from her, her home, her vehicle, where she works, or where she goes to school. Have a great day, sir. Timothy Stidham? Timothy Stidham.
Stidham?
Yeah, Timothy Earl Stidham.
He's coming up.
All right. Mr. Stidham, you have 6 charges: tampering with physical evidence, possession of drug paraphernalia, possession of methamphetamine, driving under the influence, refusing to submit to a DUI test, and resisting an officer without violence. Do you want me to appoint the public defender?
Yes, sir. And the DUI test I did, I blowed zeros 3 times.
All right, sir. Well, that just, some people don't realize it, but you're not even allowed to, the police can't even give you that test until you've already been arrested. And people think, oh, that don't seem fair. Well, it really is meant to make sure the police don't get lazy on us. And by that, I mean, they're supposed to do a thorough investigation, already made up their mind that you're under the influence, because if they did do it that way, policemen would say something like, oh, I think I smell alcohol. Let me take you down to the station. And if you blow 000, I'll let you go. So my point in telling that is you are already arrested. So blowing 000 doesn't mean you're unarrested. You're still arrested. And they may move forward with a different theory. Okay.
Yes.
So that being the case, sir, do you want the public defender?
Yes.
All right, I'll appoint the public defender. I've looked over your affidavit from Haines City Police Department. Let me take a quick look at it because I did review it. There's 2 separate affidavits. The DUI and the refusal are on its own separate affidavit, and the other charges are by themselves. The police do acknowledge that you blew 000. Now let me see based upon that. Yeah, see, typically the way it works is when you blow 000 and they think you're impaired, typically they'll ask you for a urine sample to see if you got drugs in your system. Well, it says here they asked you and you said no. So there you go. Sir, I find probable cause, going to set your bond at $5,000 on the tampering, $1,000 on the paraphernalia, $5,000 on the meth, $1,000 on the DUI, $250 on the refusal to submit to the test, and $1,000 on the resisting. Have a great day, sir. Randy Thomas? Mr. Thomas, You've been charged with possession of meth and possession of drug paraphernalia. You want me to appoint the public defender?
Yes.
I'll appoint that office to represent you. Mr. Thomas, I've looked over the sheriff's affidavit, finding probable cause for these two charges. You have 84 pages of criminal history. I'm going to set your bond at $5,000 on the meth and $1,000 on the paraphernalia. Have a nice day, sir.
Thomas. So,
Stuart Allen Thompson.
Yes, sir, Your Honor.
Mr. Thompson, oh, good afternoon, sir. You're charged with violating your probation. What put you on probation was DUI with property damage and refusal to submit to a breathalyzer. Do you want me to appoint the public defender?
No, sir, if I got to.
Okay. Fair enough. Yeah, you heard me say it, but you always can change your mind if you want a public defender later. If you qualify, the judge will appoint one. Sir, I've looked over a warrant signed by Judge Cole. He's the judge that operates out of the branch courthouse over near Haines City. He signed this on December 8th. So I find probable cause. He was pretty clear with me. He wrote down no bail, so he wants you held no bail. You won't go back to see him because he doesn't do people in jail out there. So you'll stay down here and you'll go see the M7 judge on December the 29th. Have a great day, sir.
Wow.
you have a seat.
That brings us to Ciandre Towns. Mr. Towns, you're charged with failing to appear for court on the following charges: possession of MDMA and possession of drug paraphernalia. You won't be appointed. It looks like you already have regional counsel. You already have an attorney. I'm looking at the capias that was generated by Judge Franklin. Looks like she did it way back in 23. So took them a while to catch up with you, but this was 23. But I do find probable cause for these two charges. Judge Franklin set your bond at a, oh goodness, you're benefiting from the old guidelines. It used to be, what now is 5,000, a couple of years ago was 1,000. So you're under the old scale. So your possession of MDMA, which today would be 5,000, you get 1,000. The paraphernalia, which today would be 1,000, you get 500. So your bonds are a total of 1,500. Have a great day, sir. That brings us to Long Tron.
Yes, sir.
Mr. Tron, you're charged with domestic violence battery. Do you want me to appoint the public defender to
Yes, sir.
represent you?
Yes.
Okay, I will appoint that office to represent you. Sir, I reviewed the affidavit from the sheriff. I find there's probable cause. You have been recommended for straight pretrial release. You're the second one today. What that means is I'm going to let you out of jail today, okay? You don't have to post any money. You'll be getting out of jail without doing that. But you will be supervised by pretrial release.
Sure.
So what that means is, if I didn't say it, I do find probable cause. You're going to be straight pretrial released. You'll be getting out of jail, but too late today to sign up with that office. So Monday, you're going to have to hustle down to Bartow and sign up with the Office of Pretrial Release. Sign up with them in person, calling them every week on Fridays while your case is pending. You have all the standard conditions of pretrial release. Did you ever get a victim contact? Oh, okay. Sir, here's where it gets a little tricky. Pretrial attempted to talk to your alleged victim. They could not accomplish that. So I don't know what your victim wants me to do. We're in a little bit of a pickle. So you're going to have to, I'm going to order that. You have all the standard conditions, plus special conditions 16, 17, and 18. What that means is you can't have any weapons or firearms in your possession. What it also means is until something changes with the judge, you're not allowed to have any intentional contact with the victim. This means directly, indirectly, or through a third party. Stay 500 feet away from the victim, their homes, their vehicles, where they work or where they go to school. Since you lived with the victim before you got arrested, you get to go back one time with the police within 48 hours to retrieve your essentials like medicine and clothing. Any questions, sir?
Yes, sir. You say after on Monday, after I sign something, I can get out of jail.
Yeah.
No.
Yeah. You're getting out of jail
Oh,
today.
Okay.
While your case is pending, while it's being handled,
Okay.
you have to be supervised by the Office of Pretrial Release. So you need to go sign up with them. Go check in with them on Monday. Sign
Okay.
up with them.
Yeah.
From here on out, until your case has been resolved, you have to
Okay,
call them on Fridays.
Okay.
While your case is pending, now keep in mind, you can always ask to have this changed. But for the time being, you can't have any contact with the victim. You're gonna have to find somewhere else to live until this case gets handled, okay? Or until another judge changes what I did today.
Yeah.
But you
And what,
can't have-
what is my next court day?
Your next court date probably will change, or is this a good one?
Yes.
Sir, you're gonna have arraignment on January 15th. January 15th, so that's a long time away.
Okay.
But I've appointed the public defender. You can make an appointment with them, go talk with them. Potentially, they can file any motions they think are appropriate, okay?
I read the letter from public defender, they will call me, or I have to call them.
Mr. Owens, any response to that one?
He should, actually call in, and I would probably wait, a week, and they'll have a lawyer assigned, then he can make an appointment.
Hey, sir. So give it a couple of days and call and make an appointment to see your attorney, and y'all can talk about where you go from here. Have a great day, sir.
Thank you, sir.
You bet. That brings us to,
Young Frederick.
Frederick Young.
Y'all bought, huh? Somebody said it right.
Oh, right. Did I get it right? Frederick Young. The double D is a little tricky, but,
Yeah, I know.
Frederick Young, welcome, sir. You're here on 3 violations of probation. I saw you yesterday. I know we talked about it. You were here yesterday. We brought you back today. What put you on probation was grand theft of a motor vehicle, misdemeanor driving while license suspended, and grand theft of a motor vehicle.
Yes, sir.
I can't remember. Do you want me to appoint the public defender?
Yes, sir.
Okay, I'll appoint them to represent you. These appear to be Polk County VOPs. I know yesterday we didn't have anything to hang my hat on. All I had was what first appearance paperwork from the judge in Orange County, which really didn't tell me much. It does look like the state has been able to obtain a warrant. It looks like Judge Harb signed a warrant yesterday on your case. So, yeah, he signed it yesterday. And I can tell you the allegations, or I'll read it to you. There's 2 allegations.
Okay.
It says that you failed to pay the state of Florida the amount of $30 per month towards your cost of supervision. Says right now you're in arrears $720. Then the other allegation is that you failed to successfully complete 100 hours of community service at a rate of 10 hours a month. And so there you go.
Okay.
It says additional violations on page 3. I don't have a page 3, but there's the bases right there. So, sir, Ms. Goins, any additional calls, challenges on this one? We brought him back yesterday because remember, this is the one we had that. You got another?
Yes, page 3. I don't think it will change the court's position, but just so the court has.
Thank you, Mr. Matthews. Yeah, Mr. Young, Mr. Matthews had the complete copy. Just so you know, it says you failed to make restitution. You owe about $3,200. It says you failed to comply with your instructions.
That's
Saying you didn't pay your cost of supervision. Says, I'm just trying to quickly read through it. Says you didn't pay your restitution, so that's another, they said you didn't pay your restitution, and then they're saying you didn't listen to them when they told you to pay the restitution. They're chalking at it.
That's crazy because the literally miss my probation officer in Orange County. I literally just came from her literally before she even came to my house before I got arrested, and I told her that but she know I've been paying it, but I understand
I was
though.
gonna say, don't talk about it. I don't want you to say anything, but
Yes,
I'm
sir.
getting this, I'm getting
Yes,
into
sir.
some more details here. It
Yes,
also says that on December the 8th, and this is where I think this probably comes to a head because she got arrested over there and brought in front of that Orange County judge and then brought over to us. But it says on December the 8th, 4 days ago, you were found to be in possession of a firearm. You were found to be in possession of 13 bullets or rounds. And says you didn't follow their instruction when she told you not to have a weapon. So
I don't have no guns.
yeah, I'm just letting you know that. Now this makes perfect sense now, is that's why you saw the judge over there just after the 8th and didn't know why. Now we know why. All right,
Okay.
sir, appointing the public defender, finding probable cause, holding you no bond on the 3 VOPs. Your next court date is January 5 with the circuit judge. Have a great day.
Yes, sir.
And lastly, or almost lastly, Robert Zilliner. Mr. Zilliner, you're charged with a total of 8 charges. 6 of them are new, and then you have 2 BOPs. New charges are burglary of a dwelling, resisting without violence, tampering with physical evidence, battery on a policeman, possession of cocaine, possession of paraphernalia. They said you also violated your probation on drug paraphernalia possession and exhibition of a dangerous weapon. You want the public defender on all of these charges?
I don't know what I know I got a violation of probation for my passes. I had a charge, I just got charged on it. I supposed to have a gun charge. They dropped it from a gun to a misdemeanor, and I had to attend drug classes at the probation. I completed all my drug classes except one. That's the only one I had left before I stopped going. That's why I got violated on that. But I don't have, and they're supposed to have been dropped from a felony to a misdemeanor. And they ain't supposed to. That wasn't supposed to go on my record.
Sir, on these charges that I just outlined for you, do you want the public defender?
Yes.
I'll appoint them to represent you. I've looked over the city of Lakeland affidavit. I find probable cause for all these charges.
Have you heard real quick?
Sure, go right ahead.
With regard to the top count, the unarmed burglary of an occupied dwelling, that is a dwelling, the burglary is a enumerated dangerous offense, a second-degree felony. The state will not be filing a motion for pretrial detention, and recognizing that there's a VOP, I'll leave the bonds to the court's discretion rather than make an argument.
All right.
What he's saying.
So, sir, he was saying that he doesn't think you're going to be getting out of jail because you have a VOP, but he could have filed a motion asking me to hold you in no bond and send you to see a circuit judge for a motion for pretrial detention, but he decided not to do that since you have the VOP. So with that being the case, on the 2 violations of probation, I will hold you no bond. You have 69 pages of criminal history. I'll set your bond on the burglary of a dwelling at $10,000. There'll be $2,000 on the resisting without, $7,500 on the tampering, $7,500 on the battery on a policeman, $7,500 on the cocaine possession, and $2,500 on the paraphernalia. Now, all these bonds are going to be conditions of pretrial release. If you post those bonds, must be supervised by pretrial. So check in person, sign up in person, calling them on Tuesdays and Thursdays. You have all the standard conditions plus special conditions 16, 17, and 21. No weapons, firearms, no potential contact with a listed victim, and you can't go back to the event location. Have a great day, sir. Next court date looks like it's going to be January 13.
With the votes of Mr. Zoller. Also, there's a lot of things when he said, I needed to inject something.
He's off to I think he was heading to the bathroom. He looked like he. Yeah, deputy, is Mr. Zilliner headed to the bathroom or is he available?
He's gone.
Is it something that Miss Goins wanted to see, but I heard y'all say bathroom?
He needed to use the restroom. He's about to pee himself.
I thought so. Is it something we need to bring you back for? We can if you want to.
I will do it in his absence.
Sure.
What I wanted to say is that with regards to the tampering, that particular one, where this was one where there is nothing in that affidavit that says that the officer saw him either discard the item onto the ground. The officer just said he checked the area where the defendant had gone by the bicycle in the tent, and that then he saw this item on the ground and he tested it. And apparently that gave an indication for meth. But there was nothing here. In a typical tampering case, you would have seen some officer see the person discard it. It could have been there, but there's nothing definitive that says that it was actually there's nothing in there to say it was actually being discarded by him. And it's just sort of stretched circumstantial evidence otherwise.
Mr. Matthews, I'll give you a chance to respond. Candidly, I agree with her. I know I've already found probable cause, and candidly, I've read all the case law, not all of it, but I've read the case law, and I think I'm a little liberal when it comes to first appearances because of the low threshold. But I think she makes a good argument on the tampering.
Or not for him running headlong from the police through a community member's yard, tripping over a fence, falling, and the fight being found where he fell. I think that would be a more compelling argument with respectfully. I mean, that should be condescending in the way it came out. I apologize.
No, it wasn't. It wasn't. Like I said, it's we all have roles, and I get it.
But there were other things I would have focused my argument on.
Yeah.
So
I don't think it, and candidly, I don't know if it's doing him any favors because the state's going to get the final say and he'll be getting no credit. But I'm going to find that there is no, because I know the case law, it talks about even throwing something down is not tampering. You have to actually try to destroy it or throw it down a drain or something like that. Merely dropping it is dropping it. Here, they didn't even see that. So I'm going to find no probable cause and ROR on that. I don't think, not even sure he did him a favor because he's not going anywhere, but I'll ROR him on that. And so he'll be getting out on the tampering because I do think it's a good argument. And I think that's in support of the case law. Yeah. All right. Mr. Samero, come on up.
Yes.
Good afternoon.
Good afternoon, young man. I asked Mr. Samero to stay till the end because Mr. Samero is a good kid that may have made some bad choices. I say may because allegedly he's on probation. He's a good kid that I used to coach in Little League, and I know his parents, and I wanted to tell you both and not say it in front of the whole world. But it's not something I feel compelled to accuse myself because we don't socialize. I know his parents. I've known them for years, but it's not something we socialize with. I just wanted to tell either side in case they wanted another judge on this, because I did. Mr. Samero, I think he was about, going back on my memory, I think he was at the 9-10 age level, 9 or 10, maybe 11 when I coached him in Little League.
I was 11, yeah, and you had picked me for All-Stars that year as well.
I was a good coach. No, I'm kidding. So all kidding aside, yeah, I just wanted everybody to know that I know you and we have a history. But candidly, so I don't have a whole lot of discretion. I'm not doing a bunch of anything. So some other judges have done it. So it's not like I'm the bad guy or anything. So I don't feel conflicted. I'm merely the messenger. Mr. Samero is here having been charged with violating his probation. Turn back to his page. Yeah, violating his probation on a burglary of a structure. And Mr. Samero, do you want the public defender to be appointed to represent you?
No, Your Honor. I have my own attorney. She was actually supposed to be here for first appearance. Okay. I don't know what happened.
Do you know what name your attorney? You remember her name?
Diane Berger.
Okay, yeah, I'm familiar with Miss Berger. She's been around for longer than me around here. I haven't seen her. Now, if you want me to bring you back early tomorrow morning, because they do it at like 9 o'clock tomorrow morning, I'm happy to do that. But candidly, I think the judge is going to do the same thing I'm gonna do today. But if you want Ms. Berger here to make an argument for you on your behalf, I'll bring you back tomorrow.
Yes, that's what she was gonna argue the violation for me.
Okay, if you want that, I'll be happy to bring you back. And it sounds like that's what you want.
Yes, Your Honor. Thank you, Coach.
You bet. I'm keeping my comments to a minimum because of the roles, but I wish you the best. If you ever at the courthouse and want to stop in and say hello, I'm not your judge, otherwise I wouldn't make that offer. But if you ever want to stop in and say hello and you're willing to listen to me lecture you a little bit, come on by and say hey.
I will take you up on that. Thank
Yeah.
you.
Say hello to your parents for me. Have a great day. We'll bring you back tomorrow.
Hey, Your Honor.
Deputy Fletcher, go right ahead.
Sorry, real quick. I had an officer call in about Thompson Stewart. They're curious if he's got a court date and if he received a public defender or not.
You got a private attorney?
Our attorney. Therefore. And do we have court date?
Yeah. Thompson's coming through.
I'm sorry.
You gotta look it up. One moment.
Was Stuart Thompson?
Yes.
He announced he would hire an attorney.
Yes, sir.
He seems found, he's held no bond.
Okay, his court date is December 29th at 12:45.
Fantastic.
Thank you.
Thank you.
That's where I played Little League and that's where I coached myself.
Lozano Marquez.
Today.
He works in the second
Thank
floor.
you. I've got paper on it. He was at like the city of Oregon County. And it's, and I think he did all this enough.
Y'all have a good weekend.
You just.
Harry Provencher. Your Honor, was UNCHER.
I coached.
Oh, really?
Year that he was there, so he probably might not even know that I was his dad.
It's not, so that means not.
Yeah.
Those things are getting put into my.
Yeah.
Yeah, some time to remember this poor guy, he's got an ultra contained.
I've never heard of Thompson.
See, you know.
You still have all the food?
What is the thing?
That's good. That's good stuff.
Everyone contains it when you got a can of beer. I mean, it's just ridiculous. It's one. It may be, like, standing outside of a church and everything, and everybody's coming out, that may be one thing, but just. Yes. That's weird.
Hi, guys. Thank you so much. Yeah, we had a nice couple of days today. Wasn't too bad.
Great, John.
Absolutely. Yeah, absolutely remember the name Koresh.